Faites l'appel, s'il vous plaît, Madame le Greffier.
Monsieur le connétable de Saint-Hélier. Madame le connétable de Saint-Laurent.
Présente.
Monsieur le connétable de Saint-Brelaud.
Présent.
Monsieur le connétable de la Trinité. Monsieur le connétable de Saint-Pierre.
Présent.
Madame le connétable de Saint-Martin.
Présent.
Monsieur le connétable de Saint-Jean.
Présent.
Monsieur le connétable de Saint-Clément. Monsieur le connétable de Greville.
Présent.
Monsieur le connétable de Saint-Ouen. Monsieur le connétable de Saint-Marie.
Présent.
Monsieur le connétable de Saint-Sauveur.
Présent.
Monsieur le député Savin. Madame le député Labbé. Monsieur le député Tadier. Monsieur le député Luce. Madame le député Dublé. Monsieur le député Murat.
Présent.
Madame le député Lehigara. Monsieur le député Ayen. Monsieur le député Wood.
Présent.
Madame le député Elves. Madame le député Gardner.
Présente.
Monsieur le député Gauss.
Présent.
Monsieur le député Farnham. Madame le député Moore. Monsieur le député Mezek. Monsieur le député Balash.
Présent.
Monsieur le député Coles.
Présent.
Madame le député Poré. Monsieur le député Wall. Madame le député Miles.
Présente.
Madame le député Scott.
Présente.
Monsieur le député Renouf. Madame le député Curtis. Madame le député Feltham.
Présente.
Madame le député Binney.
Présente.
Madame le député Jeune.
Présente.
Madame le député Miller.
Présente.
Madame le député Howell. Monsieur le député Binney. Monsieur le député Ferry.
Présent.
Madame le député Kovac. Monsieur le député Curtis. Madame le député Ward.
Présente.
Madame le député Wilson. Madame le député Stevenson.
Présente.
Monsieur le député Andrews.
Madame le Greffier.
Prions Dieu, notre aide soit au nom de Dieu qui a fait les cieux et la terre. Seigneur Dieu, Père éternel et tout-puissant, qui a établi les gouvernements et les puissances de la terre, pour le règlement et pour la conduite de nous, et qui nous a commandé d'avoir toujours pour but la gloire de ton Saint-Nom. Nous te prions qu'il te plaise de donner à cette assemblée le don de conseil et de priance, d'unir le cœur et les affections de tous ceux qui la proposent, et de les conduire tellement, toi-même, par ton Saint-Esprit, toute leur délibération, et en compagnie de ta bénédiction, aille aussi sur bien et au soulagement du peuple qui se plus de connaître le soin. Par nous t'en prions au nom et par le mérite de ton Fils bien-aimé Jésus-Christ, notre Seigneur, qui nous a enseigné à t'invoquer en disant: Notre Père, qui es aux cieux, ton nom soit sanctifié, ton règne vienne, ta volonté soit faite en la terre comme au ciel. Donne-nous aujourd'hui notre pain quotidien, et nous pardonnons nos offenses, comme nous pardonnons à ceux qui nous ont offensés. Ne nous induis pas en tentation, mais délivre-nous du mal. Car à toi la haine, la puissance et la gloire, au siècle des siècles. Amen. Monsieur le connétable de Saint-Ouen.
Sir, the Constable of St. Juan is accompanying a close family member at a hospital appointment and hopes to be with us as soon as he can, sir. Ask his excuse.
And is content to mark the Connétable excusé? Excusé.
Madame le député Labbé.
So Deputy Library is in Cambridge. She's hosting an international development conference with Jersey Overseas Aid.
State's business.
States business, yeah.
Thank you. State's business.
Madame le député Dublé.
Présente.
Madame le député Moore.
Malade.
Jurez que Madame le député Moore est tellement indisposée qu'elle ne peut pas assister aux états sans exposer sa santé.
Malade.
Madame le député Poré. Madame le député Howell.
Défaut.
Madame the Deputy Kovac.
Deputy Kovac is accompanying one of her children to a medical appointment, and then she'll be joining online. So can she be excused until she arrives online?
His contents marked Deputy Kovac, excusing. Excusing.
Madame le Deputy Wilson.
Présente.
Hésitaires sont constitués. We return to the debate on the draft cyber security law. Assistant Minister, how do you propose the articles in second reading?
Sir, this law has over 40 articles which work together as a whole to implement the necessary aspects of the functions, including formalising the Jersey Cyber Security Centre, designating operators of essential services, enforcement provisions and clarifying information sharing provisions. So they are very much interlinked, and on this basis, unless any member wants me to take them in their detailed parts, I propose the law en bloc.
Thank you, Assistant Minister. Are the articles seconded? Thank you. Does any member speak on the articles in second reading? All those in favour kindly show. Thank you very much. The articles are adopted in second reading. Assistant Minister, do you propose the matter in third reading?
I do, sir.
Thank you. Is the matter seconded? Thank you. Does anyone wish to speak on the articles as adopted in second reading and third reading? We may need to stop in a moment. There's a problem with the sound, but I think we should finish this this law. Does anyone wish to speak on the articles in third reading? Deputy Morello.
Thank you, sir. Yes, it's just a matter. It looks like this is going to pass unanimously. I'm grateful to the Assembly for that. Very grateful. I'm pleased the Assembly takes the issue of cybersecurity as seriously as I think it needs to. I just want to kind of go back to where I started my speech yesterday in the first reading. That's to thank Deputy Scott for all the work that she's done and the Economic and International Affairs panel for the work that they've done. I also want to thank Deputy Alex Curtis for the work that he did starting off this when he was an Assistant Minister beforehand as well as the work of the JCSC, which has been developing at pace over the last few years and is now, no question, Jersey is in the leading position as kind of Jersey's guiding light on matters cybersecurity, and as I said yesterday, is working with all sorts of organisations across the island to enhance cybersecurity and help them to respond to incidents. So just wanted to get those matters of thanks on record, sir. Thank you.
Thank you, Minister. Does anyone else wish to speak in third reading? I call upon the Assistant Minister to reply. Assistant Minister.
Thank you, sir. I thank the Minister for his words. I also thank members for their support in the first and second reading, and Deputy Alex Curtis, indeed, for his work on the law, which has been a team effort. Among the people who have shaped it are islanders who have a professional interest in cybersecurity, and many of them lose sleep at night, quite regularly. They get sidelined by people who think that cybersecurity isn't that important, that it's not anything to do with them. And they get ignored when making reasonable requests when what they need is support. So I'm very grateful to members for their support of the law. And now that cybersecurity has been brought into the spotlight, I hope that we all can endeavour to become good cybersecurity practitioners, because these experts and champions, because these experts need every one of us to champion their cause and show leadership. I'm going to give a particular mention to the JCSC and the Channel Island Information Security Forum. The soon-to-be director and the chair of the Channel Island Information Security Forum are in the public gallery today and have done some amazing work. Thank you. And they are a resource for us all. The Channel Island Information Security Forum is run by volunteers who are professionals in cybersecurity, and they host really inspiring annual conference. I've been to it and I've listened to people whose job is to just penetrate buildings and systems, and my God, the tricks that people can do. It's really quite.
My God is unparliamentary.
Sorry.
So you need to withdraw.
Sir, it's really quite incredible. And so those conferences and their workshops have been highly informative for me, and I thank the sponsors of those too. So thank you to all these people who helped shone a spotlight on our cybersecurity needs, and all those who have provided their feedback as part of the law drafting process. I also acknowledge and I'm grateful for the hard work of the officers, both within government and also within our non-ministerial departments, who have worked together to bring forward this draft law. I call for the appel, sir.
Thank you, Assistant Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. I can announce the law has been adopted unanimously in third reading, 43 votes for. Greffier, has the sound issue been resolved?
So I'm informed that it has now been resolved and is improved, but unless the greffier knows otherwise.
Yes. Good. The next item is the draft Limited Partnerships Amendment Law lodged by the Minister for External Relations. The main respondent is the Chair of the Economic and International Affairs Scrutiny Panel. I'll ask the greffier to read the citation.
Draft Limited Partnerships Jersey Amendment Law 2000, a law to amend the Limited Partnerships Jersey Law 1994 to make provision for eligible foreign limited partnerships to continue in Jersey as limited partnerships and, in consequence, to repeal the Limited Partnerships Continuous Jersey Regulations 2023. The states, subject to the sanction of His Most Excellent Majesty in Council, have adopted the following law.
Minister.
Thank you, sir. I'm sorry to inform members that unlike my first bit of legislation at this sitting, which was exciting, this is not exciting. It's a simple housekeeping measure. Members will be aware of the triannual regulations, the Limited Partnerships Continuation Jersey Regulations 2023. What this amendment to the primary law does is, in effect, take the legislation that's in the triannual regulations, place it into the primary legislation and repeal the regulations. Therefore, the legislative change, there is no legislative change, it's just that it will now be in the primary law by way of this amendment, and I commend the amendment and the repeal to members for their support, sir. Thank you.
Thank you, Minister. Are the principles seconded? Does any member speak on the principles? David Tellier.
Thank you, sir. Just on behalf of the Economic and International Affairs Scrutiny Panel, sir, to say that the panel welcomes the initiative to incorporate the existing regulations into primary legislation. We think this makes more sense to give it more permanency, more certainty, and we note that it will strengthen the island's competitiveness and align it with other international finance centres that offer comparable continuance regimes, sir. So we're happy to support and encourage members to also support the draft law and its objectives.
Thank you, Deputy. Does anyone else wish to speak on the principles? I call upon the Minister to reply. Minister.
So yes, I'm grateful to the scrutiny panel for their work in scrutinising these this change in approach, which, as I say, has got the same legal effect. And for all their work, there's more work coming. I'll be pleased to know between now and the election, hopefully. But as ever, I'm grateful for their scrutiny of this important work, and I commend this amendment, the principles of which to members, and call for the appel.
Thank you, Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. I can announce the principles were adopted unanimously, 40 votes for. Deputy Talia, can you confirm that your panel wish to scrutinise the matter no further?
We don't wish to scrutinise it any further, thanks.
Thank you very much. Minister, do you propose the articles in second reading?
Indeed, I do so, and I propose them en bloc. They are, as I just said, in the first reading, and I ask for members' support. I'll endeavour to answer any questions if they may arise.
Thank you, Minister. Are the articles seconded? Thank you. Does any member speak on the articles in second reading? Those in favour of adopting the articles kindly show. Thank you very much. The articles are adopted in second reading. Minister, do you propose the matter in third reading?
I do, sir, and I thank my officials for the work that they've done in this regard. The original continuance legislation, as I said, were triennial regulations, and they were brought forward during COVID. So it just goes to show, sir, the long influence that COVID has upon us, as we're aware in other fields as well. But I commend the amendment to members in third reading.
Thank you, Minister. Is the matter seconded in third reading? Thank you. Does any member speak on the articles as adopted in third reading? Thank you. Is the appel called for?
Please, sir.
Appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. I ask the greffier to close the voting. I can announce that the law is adopted unanimously in third reading, 42 votes for. I'll move on to the draft register of names and addresses amendment law lodged by the Chief Minister. The main respondent is the Chair of the Corporate Services Scrutiny Panel. I ask the greffier to read the citation.
Draft Register of Names and Addresses, Jersey Amendment Law 2000, a law to amend the Register of Names and Addresses, Jersey Law 2012. The State, subject to the sanction of His Most Excellent Majesty in Council, have adopted the following law.
Chief Minister.
Thank you, sir. Deputy Miller will be acting as rapporteur.
Yes, Minister.
Thank you, sir. Sir, I think this amendment is also back firmly in the exciting category, because it should help finally resolve our issues, or certainly one of our biggest issues around credit card availability in Jersey. Sir, members of the Assembly will already be aware of ongoing efforts to enable the supply of information to UK credit reference agencies with the aim of improving access to credit products for islanders. In 2023, the Register of Names and Addresses Law was amended by the Register of Names and Addresses Amendment Jersey Law 2023, the 2023 amendment, to allow the Minister to share information with credit reference agencies. Significant progress had been made towards implementation. However, it was later identified that the strict processing limitations in that amendment
would prevent legitimate use of information for law enforcement purposes, specifically the ability for a UK credit reference bond to a UK police request. This type of processing is standard in GDPR compliant jurisdictions and is reflected in the Data Protection Jersey law. The restrictive provisions introduced in the 2023 amendment, however, closed the door to this and have since prevented the supply of information to credit reference agencies, as we are aware that law enforcement access is built into their automated processes in line with GDPR legislation. This proposition seeks to reopen that door and permit processing for law enforcement purposes. Adopting this legislation will enable the supply of information to UK credit reference agencies, which is planned for Q2, subject to the timelines of the Privy Council. In summary, this proposition amends the specific purposes for which supply of information to credit reference agencies is restricted to include for a law enforcement purpose as defined by the Data Protection Jersey Law 2018, and it makes a minor amendment to layout in line with current drafting standards. Sir, I move the principles. Thank you.
Thank you, Minister. Are the principles seconded?
Yes.
Does any member speak on the principles? Deputy Miles.
Thank you, sir, and I rise to speak on behalf of the Corporate Services Scrutiny Panel, just to assure the Assembly that the panel has considered and questioned the Government's work to facilitate the credit checking processes undertaken by credit reference agencies and to address obstacles to the provision of credit card services in Jersey. We have sought assurances that the amendment law satisfies key governance and data protection considerations. And this assurance includes engagement between the Government and the Information Commissioner for Jersey, the Data Governance Officer within Employment, Social Security and Housing, and the completion of a data protection impact assessment. So whilst the implementation of this amendment law will include the automatic extraction of government data, an opt-out process has been developed and a communications plan is being developed by Government in relation to the proposal. So the panel acknowledges that the current provision of credit card services in Jersey is limited by the current administrative arrangements regarding the sharing of names and addresses. However, the panel is satisfied that in making these proposals, the Government has taken adequate steps to satisfy important data protection and governance considerations, with an opt-out for islanders from the proposed changes, and that a communications plan regarding the proposals is in development. So the panel considered that the amendment law is a practical step to support the credit checking and due diligence undertaken by credit reference agencies and facilitate the expansion and improvement of credit card services in Jersey, which will be very welcome to many of our citizens. Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles of this law? I call upon the Minister to reply. Minister.
Thank you, sir. Sir, I thank the scrutiny panel for their review and for their words in support and for supporting this legislation. I think the position has slightly improved in any event since 2023. I think there is a new banking entrant which is offering credit cards to islanders, and another of our more established banks is offering them. I think others who were less certain are now reconsidering their position. So I think the landscape generally within the island is better. But this piece of legislation will certainly help all of us if we are looking for credit products, particularly from UK providers. So, sir, I propose the article, sir. Sorry, I call for the appeal.
Thank you, Minister. The appeal has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. I can confirm the principles have adopted unanimously. 41 votes for. Deputy Miles, can you confirm that your panel have scrutinised this matter?
Yes, we have, sir.
Thank you very much. Minister, how do you propose the articles in second reading?
I'd be grateful if they could be taken on block, sir. There's only 3 of them.
Thank you. Are the articles seconded? Thank you. Does any member wish to speak on the articles in second reading? Those in favour of adopting the articles kindly show. Thank you very much. The articles are adopted in second reading. Minister, do you propose the matter in third reading?
Yes, please, sir.
Thank you, Minister. Are the articles seconded in third reading? Does anyone wish to speak in third reading? Is the appel called for?
Yes, please, sir.
Appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. All members have the opportunity of casting their votes. I ask the greffier to close the voting. I can announce that the draft law has been adopted unanimously in third reading, 42 votes for. The next item is the Criminal Justice Young Offenders Amendment Number 2 law, lodged by the Minister for Justice and Home Affairs. The main respondent is the Chair of the Children, Education and Home Affairs Scrutiny Panel. I ask the greffier to read the citation.
Draft Criminal Justice Young Offenders Jersey Amendment Number 2 Law 2000, a law to amend the Criminal Justice Young Offenders Jersey Law 2014 to provide for the early or temporary release and supervision of young offenders serving youth detention in secure accommodation, a young offender institution or the prison, and to amend the Criminal Justice Young Offenders Placement Panel Jersey Regulations 2016, the Criminal Procedure Jersey Law 2018, the Prison Jersey Law 1957, and the Prison Jersey Rules 2007 for connected purposes. The states, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
I ask the Minister to propose the principles. Minister.
Thank you, sir. I'm pleased to bring this amendment before the Assembly today. I'm pleased because if the Assembly approves this amendment, I can say it will make a significant difference to young offenders, and particularly to those serving sentences of youth detention within the secure accommodation, or in other words, Greenfields Secure Children's Home. I say that, sir, because the main purpose of this amendment is to allow for under 18s serving youth detention in secure accommodation an ability to gain both temporary release and early release, or in other words, remission. Currently, they have no entitlement to this under the law, unlike their counterparts and adults within the prison estate. I would stress that without this amendment, we are, as an island, treating children and young people within our secure children's home more harshly than their peers and even adults serving their sentence within the prison estate. This cannot be right and is a position I'm sure the Assembly will want to correct. By passing this amendment, we will also be making sure we treat male and female young offenders equally in respect of where they must be remanded or serve their sentence of youth detention. We will ensure greater parity for all young offenders and make Jersey a more compliant jurisdiction with the UNCRC, which I know is something we all are committed to. Sir, before going into the detail of this amendment, it might be helpful to provide members with some context. The current position is that if you're a child 10 to 14 years, or a young person 15 to 17 years, that has committed a crime that warrants a sentence of youth detention from the court, it is up to the placement panel to make the decision as to where the best place is to serve their sentence. The choice ultimately is between Greenfields or our secure children's home or Lamoy Prison in a designated area for young offenders. The difference between the prison and Greenfields is significant, and the placement panel will always inevitably choose Greenfields, as it is the most child-friendly environment and managed by children's service care staff. As Minister for Justice and Home Affairs, I believe this must be in the best interests of children and young people. And this is certainly a view supported by others, including the authors of various inspections and reviews. Whilst secure accommodation is considered the most suitable environment for under 18s to serve youth detention, there are some significant issues that this amendment addresses. Sir, if I may, I will explain to members the provisions of this amendment and start with that of temporary release. Sir, temporary release is perhaps best described as an assessed opportunity that allows for a young offender to have, for example, a family visit, access to education or training, or therapeutic opportunities in the community. This, we know, will help a young person gain opportunities that are pro-social and provide a better transition for them to reintegrate back into the community. This helps reduce their risk of reoffending, and if they are not offending, we of course have fewer victims. The goal we have for temporary release was an action highlighted by the Greenfield Review undertaken in 2019. That review said that we should work on a way for children and young people to access education, work and opportunities in the community. So this is what this amendment will provide. Without doing this, a young offender will be deprived of their liberty for the whole of their sentence and released back into the community without transition. This can be overwhelming and certainly not the best way to help our young people go on to lead a pro-social life where they can put their offending behind them and be an absolute asset to our community. I would again highlight that in context, young offenders and adults within the prison estate are and do gain temporary release. To assure members of any concerns they may have, I would say that the use of temporary release is common practice in many jurisdictions. That is given as a privilege only after they have been assessed as suitable. Temporary release is also time limited and offenders can be recalled if needed. For example, if they were not complying with a condition such as not attending an appointment. If a young offender were not to return after a period of temporary release or were recalled, they would also, this amendment, be unlawfully at large, and the police would return them to Greenfields or the prison estate. The decision whether to allow a young offender to be temporary release, for what period and under what conditions, will be taken by the placement panel. For those young people serving their sentence within the prison estate, that decision will remain with the Governor. Sir, regardless of location and to be human rights compliant, a new provision is made that allows them or someone with parental responsibility to appeal against a decision made to modify the conditions of temporary release or recall, and this would need to be on the grounds that a decision was unreasonable. Sir, the most significant part of this amendment is that of allowing for early release, or in other words, remission. This is another right that is an option for young offenders and adults within the prison estate, but not yet for children or young people within Greenfields. When looking at the prison law, the grounds for early release are stated as being for industry and good conduct. In practice, sir, prisoners are always customarily released at the two-thirds point. For under 21s, under the law, they are then supervised by a probation officer and must comply with written requirements such as letting the probation officer know of any change of address. Under the draft law, provision is now made for all young offenders, including those within secure accommodation, to gain early release at two-thirds point of their sentence. The law is, however, changed, so early release is the presumption. There is provision within the law for early release to be delayed if necessary. The prison governor, in the case of the prison estate, and the panel, in the case of secure accommodation, be the ones to make that decision. However, they could only do this if they had good grounds, such as there was significant risk of that person that could cause someone harm. Sir, I would envisage that it would be rare that any young offender would be denied early release under the new amendment, and this will be in line with current customary practice for their counterparts in the prison estate, which is well established. As in the case of for young offenders currently under law when they are sentenced to 4 months or more, they are released with supervision by the probation service, receiving what I believe to be good support and oversight. The amendment, if passed, introduces a set of standard conditions that every young person must comply with. They include conditions such as be of good behaviour, not to commit an offence, and to reside at an address approved by the probation officer. These are very similar to current conditions after release. So, I believe these standard conditions should be enough to allow for release and to provide sufficient intervention and support. However, I'm aware that for some young people, they may have risks or needs that require more intervention or support. To deal with this, the law will allow for additional conditions to be made by regulations. These are currently being drafted and it will be for the next government to approve. However, the standard conditions will cover the foreseeable requirement and it will be harmful to delay these new release arrangements for 6 months for all details to be completed. So, those additional conditions will be extensive to cover a range of needs and risks. For example, not to have contact with a victim, to undertake programmes of activities that address specific offending behaviours or receive home visits for mental health worker. Some conditions will impinge on a young person's offender's lifestyle and therefore there are safeguards in this amendment, namely that they can only be imposed if they are necessary and proportionate. For the purposes of supplementing the standard conditions and for the purpose of protecting the public, preventing reoffending and or securing successful reintegration into the community. So those additional conditions will be able to be imposed by or cancelled by the Governor or the panel at any time during the supervision period. But before the conditions are made, there must be consultation with the young offender and the probation officer. Under the amendment, communicating these conditions must be done in writing and in appropriate language. They must also be given copies in appropriate language that is understood. So, it should be noted that adults have never been subject to any statutory post-release supervision. In my opinion, that cannot be right, and so a law is in the process of being drafted. The intention is that adult prisoners will also be subject to standard supervision conditions with a suite of additional conditions that can similarly be made to address any specific needs or risks. So, if passed today, this law will come into force with transitional provisions in respect of supervision of young offenders who would already be under supervision before the commencement of this law. This includes provision that a transitional young offender must continue to comply with the original written requirements of their supervision until the end of their supervision period, and that the original written requirements cannot be modified or cancelled, but the panel or governor could impose additional supervision conditions. As with temporary release, it is important that this amendment introduce an appeal process that can be made by the young offender or on their behalf by a person with parental responsibility. The grounds for appeal introduced in that additional conditions were unreasonable in all the circumstances of the case. Under the amendment, any appeal must be made to the judicial greffier and that appeal heard by the chair of the youth panel. The court may then confirm or overturn the governor's or panel's decision to impose additional conditions or order that they consider their decision and have regard to the opinions expressed by the youth court. So, whilst the amendment's primary intentions are to ensure temporary and early release is available to children and young people, serving a tension of youth detention in a secure accommodation, there have been other necessary and consequential amendments. These have included amending the placement panel, court and ministerial powers. To facilitate early and temporary release, the remit of the placement panel under the law has been extended for them to carry out the role as decision maker for temporary and early release of young offenders within the secure accommodation. As I've already outlined, appeal processes have also been introduced to improve human rights compliance. In doing this, provisions have been made for the chair of the youth court to hear those appeals. changes have been made to ministerial responsibilities, most significantly to transfer of functions in respect of children and young people sentenced to youth detention or remanded into custody, moving from the Minister for Justice and Home Affairs to the Minister for Children and Families. This change is made on the basis that while children and young people are young offenders, they are firstly and primarily children, and when in secure accommodation, they are in a secure children's home managed by children service staff and under the law looked after children. These amendments therefore take a child-first approach, which I know is an approach shared by the Children and Families Minister. Sir, our secure accommodation is in its management subject to care regulations. Whilst these are seen to be currently appropriate, there is an awareness that those children and young people who present particularly challenging behaviours are as a last resort accommodated within the prison estate, where they fall under prison rules, which are address specific areas for custody. The environment of the prison estate, as I've already highlighted, is not the most appropriate environment for children and young people. So as a future proofing measure, provision has been made to make regulations for the purposes of regulating and managing higher security secure accommodation instead of prison for the assessment, treatment, discipline, control, care and integration back into the community of young offenders, if that is required in the future. Sir, this amendment also now makes the treatment between male and female young offenders equitable. In the past, when a female young offender had to go into the prison estate, they entered the adult wing, whereas a male would be accommodated in a Young Offenders Institute, or YOI. The YOI in the prison is no longer a permanent part of the prison due to the low numbers of young offenders. If a young offender enters the prison estate now, an area will be delegated as a YOI. This is the same for both males and females, and so the amendment reflects this position, bringing parity across the genders. Finally, sir, this amendment ensures that communication and written notifications to young offenders takes account, as far as practicable, the young offender's age and maturity, whether English is their first language, and whether they have a mental, physical, or sensory impairment, learning disability or difficulty, or a condition affecting their ability to communicate, understand, or process information. Similarly, communication to a person who has a parental responsibility for the young offender must also be given in a way that takes account, if practicable, their needs. In concluding, sir, this amendment allows for children and young people serving a sentence of youth detention an ability to gain temporary and early release from secure accommodation. It also brings greater parity for young offenders, regardless of whether they are serving youth detention within secure accommodation or within the prison estate. I would also like to add, sir, that the amendment is, in my view, in line with recommendations of the Greenfield Review, Youth Justice Review and Prison Inspection. The amendment is ECHR compliant, and in addition will improve the island's compliance with the UNCRC. Sir, I therefore ask the Assembly to give full support to bring this amendment into force. Sir, I propose the proposition.
Thank you, Minister. Are the principles seconded? Yes, sir. Thank you. Does any member speak on the principles of the draft law? Conor St Peter and then Deputy Catherine Curtis.
Thank you, sir. And I thank the Minister for Home Affairs for the very comprehensive speech, which means that I can considerably abridge mine now. It will come as no surprise that I strongly support the Minister for Justice and Home Affairs in bringing forward this amendment. I do so as the Minister with responsibility for children and young people in our island, ensuring that their rights, welfare and best interests are upheld at every stage, including when they are deprived of their liberty. What is proposed is a child-first approach. At the heart of this amendment lies a single truth.
A child in custody is still a child. They do not stop being a child because they have committed an offence. They remain entitled to care, protection, education, family life, and the rights set out under the UNCRC. As the Minister said, Greenfields is a secure children's home staffed by residential care practitioners. Their work is rooted in safeguarding and development, and this amendment aligns our youth justice legislation with the lived reality. It ends unfair disparity. This results, but currently we are inconsistent with Article 37 of the UNCRC, and this amendment aligns us with that, which requires detention to be used only as a last resort and for the shortest appropriate time. It also supports reintegration. It's very important that someone coming close to release should have the opportunity to gradually return to education or training and be safe and supported with further family contact. It also strengthens our UNCRC compliance. Article 3, best interests of the child as a primary consideration. Article 12, ensuring the child's voice is heard. Article 37, detention is only used when necessary and for the shortest possible time. Article 40, supporting the rehabilitation and reintegration. Sir, as Minister for Children and Families and Assistant Minister for Justice and Home Affairs, I work closely with the Minister and support the transfer of responsibility for children in secure accommodation to myself. These children are looked after children, and their welfare should sit within the department, built on safeguarding and child development principles. It also brings to an end the current workaround, which has been used recently and which is very cumbersome, which has allowed, in effect, remission to be given, but under a very complex procedure. Sir, this amendment is fair, proportionate and child-centred. It restores parity, strengthens rights, improves reintegration pathways, and ensures that every child deprived of their liberty is treated with dignity and supported to succeed. For these reasons, I fully support the amendment and commend it to the Assembly and ask you all for your support. Thank you, sir.
Thank you, Minister. Deputy Catherine Curtis.
Thank you, sir. I just speak as Chair of the Children, Education and Home Affairs Scrutiny Panel. I'll just summarise some points from the panel's comments paper. I'm not sure if all States members have seen this, as we submitted the paper later than usual due to our workload. But this is a very straightforward amendment law. It's to enable children and young people to have access to temporary or early release, which can already be accessed by over 18-year-olds who are serving a sentence at the prison. As well as the equality to access, this change to the law allows for a more gradual transition back into the community. The Jersey Probation and Aftercare Service have been consulted throughout the process and are confident that they can manage this work within current resources. This amendment law will also result in a change to the main ministerial responsibility to the Children and Families Minister, which aligns with the Child First principle. The panel did note a lack of data in this area, and the Minister responded that this would be better managed in future through the Building a Safer Community work. So just to conclude, the panel supports the amendment law.
Thank you, Deputy. Deputy Doublé.
Thank you, sir. And I did read the panel's comments, and in fact they answered several of the questions that I had down to ask the Minister, including one about how many children had been remanded. What I'm not entirely clear on from that table is whether that was each occasion a child was remanded, or whether that is the individual children, if that makes sense. So if the Minister could clarify that. I think for the latest number, I think it was but it looks like it has been reducing. It's on a downwards trajectory. I listened with interest to the Assistant Minister's comments as well about the UNCRC, and what I wanted to remind members is that actually we are still not in the place where we have fully incorporated the UNCRC, and I think part of the reason for that, one reason is that it takes time to do so, but another reason is that we are simply not compliant with it as yet. And I think the Minister made it very clear that this is a step towards Jersey being compliant with the UNCRC. So my query to the Minister really is, what are the following steps after this? How close does this bring us to being fully compliant with the UNCRC, and do we have an estimate of where we are in the steps of working towards that full compliance? How many more years, how many more amendments will it take for Jersey to arrive there? I think something I picked up on in the Minister's speech, that she spoke about Greenfields as a child-friendly environment, and I just wanted to gently challenge that. I know that and I have been to Greenfields, it was a few years ago now, but the staff do an amazing job and they do the very best they can, but the bones of that building is not a child-friendly environment. It is an incarceration environment, and I think there's no getting away from that. And recommendations have been made for smaller, homelier, therapeutic care environments that should be where those children who are committing crimes should be placed. And I'd like the Minister to comment on where we are in terms of establishing those alternative environments, because it is my belief that Greenfields shouldn't be used at all. Previous speaker has mentioned Article 37 of the UNCRC and the deprivation of liberty. I am really hopeful that this amendment might result in no children going to our adult prison. Does the Minister think that this is enough to prevent any children being incarcerated in our adult prison? Will she expect that number to be 0 for the adult prison? And as I sometimes do, sir, I want to cast members' minds back to the care inquiry, because incarceration of children, not just in Greenfields, but also in some of our care homes, was something that was raised by the care inquiry. And as far as I'm aware, much progress has been made in terms of our care homes. But sir, the children, and I think the Minister and the Assistant Minister both did a good job of reminding us that actually we mustn't think of these children as criminals, that they are children. And some of the children who actually when they are looked after children in these institutions, we are legally their parents and we are responsible for them. And for some of those children, that will have been the case, that States members will have been their corporate parent for most of their childhood, or a huge chunk of their childhood, and therefore we are responsible for the way that they have grown up, and for the failures, I think. And I think that we need to actually own that, and that word failure does need to be used, because these children are children who have been failed by the culture and the system and the services that we have in our island. And I think that we ought to feel sorry about that and feel regret about that, and continue our resolve to eradicate the incidences of children experiencing similar trauma today in our island. So I've been a States member for 11 years, and there are some members in the Assembly who may have been a States member for the entire lifespan of some of these children who are in that Assembly. And I think this is an opportunity for us to re-strengthen our resolve that no child should experience trauma in their lifetime that leads to them committing criminal acts, and for us to take responsibility for that. I think that's everything that I wanted to say. But yes, the big thing that I really would like to hear from the Minister is the pathway to full incorporation, and where does this put us on that pathway? How much closer are we to that full incorporation? Is that still a strong commitment of the government? I'm hoping that commitment will carry through to the next government, so that we can achieve that. And is it feasible that that can be achieved in the next political term? Thank you, sir.
Thank you, Deputy. Does anyone else wish to speak on the principles? Deputy Rob Ward.
Thank you, sir. It's interesting to follow because I do agree no child should be, when we get to a position where a child has to go into any form of, I don't know what the word is, custody, then of course we failed as a society. However, there is a reality that we do fail as a society too often for all sorts of reasons, poverty being the main one of those reasons, I believe. Poverty of opportunity, poverty of housing at home, the poverty of all sorts of things, and that's a wider social issue that I think we should all be addressing, and I hope it is a main issue in the next election. But there is a reality that it does happen. I think what this law, this change does is make a step forward. And I think a lot has been said about the right things that are happening. And we must do everything to break cycles as best we can. I think one of the important parts of this law that's perhaps hidden a little bit is the importance of supervision. Because when supervision, whatever word you use, whatever, you have to use a word in a law, but I think the idea that reintegration, that care, that recognition that if a young person ends up in a situation where they are in some form of custody, it's not about punishment, it's about reintegration and giving that person a chance again after what's happened. And I think that supervision is really important. It's important for anyone who goes to prison. It's important for anyone who loses their liberty, that afterwards they're given there was an opportunity to rebuild a life. And young people, we can break those cycles if we get that part right. And I think that is the point I would like to point out, so the importance of that part of rebuilding young people's lives once there's been mistakes. So I've encountered many people, young people in my years, who I see them now and they say, oh, I wasn't too great at school, but I'm doing okay, and they have rebuilt their lives. And when I was younger, there, but for the grace of a greater deity, may go ourselves, and that didn't happen. So we all have to be realistic about what we do. I think this is a step forward. Of course there's a lot further to go. Of course there is. Let's bear that in mind. And I agree with that. But I think this is a definite step forward. So thank you.
Thank you, Deputy. Does anyone else wish to speak on the principles of the draft law? Deputy Wilson.
Thank you, Sarah. It's just that I wondered whether or not the Minister had considered, when describing the issues around detention, the interface with young people's mental health services. And really it's a plea to ask whether or not, in considering what kind of environment detention takes place, that the needs of young people who experience mental health issues during a period of, shall we say, criminality can also be considered, and whether the law is able to make any provision for how people who also have a criminal history as well as a mental health problem can actually be accommodated under these arrangements. Thank you.
Thank you, Deputy. Does anyone else wish to speak on the principles? I call upon the Minister to reply. Minister.
Sir, firstly, I'd like to thank those that have participated in this debate and thank for their support. In relation to the questions asked by Deputy Doublé, it is identified that there is a lack of data or good data in this actual domain, and therefore that is why a data partnership group has been established under the Building a Safer Community to better coordinate that particular information. Because, of course, the only way that we can identify how we're progressing and doing things is by actually being able to exactly know what are the circumstances. The only sort of information that I have is in relation to those numbers is that between 2023 and 2025, 2 youth detention orders were made against the same individual during that year. And of course were counted as two separate things. There is no data in relation to the raw court numbers. So I think that is clearly something that needs to be worked on in order that we are able to achieve that. The Deputy also asked about the moving forward in relation to our compliance with UNCRC. I think the thing is, it is like a lot of things, and I fully understand the Deputy's concerns, because I, like her, think that we need to address a number of things in relation to young people in order that we do not end up with young people in any of our facilities and taking away their liberty. We, as I said, are working this forward, and I'm not able to give her a total timeline of where we will be in relation to the UNCRC at this particular time. This is obviously work that is going on in relation to the Children and Young Persons, Children and Families Minister, whereas my responsibility in relation to this, although it is involved across the piece, it is obviously more aligned to this in relation to them coming into a custodial situation. In relation to what, as I said, in relation to what the Deputy Wilson is asking about mental health, I think it is imperative that in any situation where young people are coming into our care, they will be, or should be, I should say, assessed in relation to their mental health condition. When they come in, particularly if they are arrested, they would be assessed at that point, or one would hope that they ought to be, if all of the things under the police and detention was all looked at and assessed. I fully agree that sometimes our facilities, and it will be both in the prison estate and in somewhere like Greenfields, that a lot of the people that come into those facilities will have mental health issues, they will have addictions, etc., etc. And I think all we can do, sir, is continue to invest and make sure that those facilities, that those individuals have got availability to, are as best as we can provide. I'm hoping that I have actually sort of answered those questions that people asked, but obviously if I haven't, I'm happy, should they wish to speak to me after this debate, that I can answer their questions more fully, sir. Thank you.
Thank you, Minister.
Sorry, I propose the principle, sir, and I'll call for the appel.
Thank you, Minister. The appel has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. And I can announce the principles have been adopted unanimously, 44 votes for. Deputy Catherine Curtis, can you confirm that your panel has no wish to call this in? Thank you very much. Minister, do you propose the articles in second reading?
Yes, sir, please. I thank the Assembly for agreeing to the principles, and I would like to propose the articles en bloc, sir.
Thank you, Minister. Are the articles seconded? Yes, sir. Thank you. Does anyone wish to speak on the articles in second reading? Deputy Doublé.
Thank you, sir. Very briefly, I think I didn't make it clear enough, actually, amongst all my questions, how grateful I am to the Minister for bringing this, and that I think it's an excellent proposition. I did have one more question, though. Can I ask how this is being communicated to the children in question? And also, I think one of the previous speakers mentioned that there is always going to be a need for this. I partially accept that, but one thing I wanted to make clear was that the UNCRC states that it should always be a last resort, and that there are other options that would include care and therapeutic settings rather than simply a punitive setting. So, yeah, thank you.
Thank you, Deputy. Does anyone else wish to speak in the second reading? I call upon the Minister to reply. Minister.
Thank you, sir, and I thank Deputy Doublé. And she's just reminded me, sir, of something that I probably didn't respond to in relation to. I think when the Deputy talks about detention as being the last resort, I 110% agree with that principle, sir. And I think it should only be as the last resort. And I think we need to identify as an island that we need to start the work early. And that is why we need to invest in children and young people from when they are actually arrive in our world, sir. And we shouldn't be waiting until we come into contact with them later in life when they are facing challenges. So I think I fully agree 100%. I think in relation to the situation of secure accommodation, in my view, is always going to be not an ideal from the point of view that for it to be secure, sir, it means that somebody has had their liberty taken away, and we must always work towards avoiding that situation at all costs, sir, and I maintain the proposition. Thank you, sir.
Thank you, Minister. Those in favour of adopting the proposition in second reading kindly show. The appeal has been called for. Members are invited to return to their seats. I ask the greffier to open the voting. Four members have the opportunity of casting their votes. I ask the greffier to close the voting. I can announce the articles have been adopted unanimously in second reading. 44 votes for. Minister, do you propose the matter in third reading?
Yes, sir, I do. So, in conclusion, I believe the amendment before the Assembly today is proportionate, fair and necessary. It balances the needs of children and victims. It will improve rehabilitation outcomes and strengthen compliance with international standards. This includes allowing children and young people serving youth detention within the secure children's home the ability to gain temporary and early release. This is a provision already afforded to their contemporaries and adults within the prison estate. So I was reminded that I'd failed to answer the question in relation to how will this be communicated to the young people. And I think it's clear that they probably will find out, sir, fairly swiftly, but that I will give to the Children's Minister to convey to the team who look after these young children so that they are fully aware of what their new rights will be. I therefore ask the Assembly to give their full support in bringing this amendment into force, sir, and I call for the appeal.
Thank you, Minister. Is the matter seconded in third reading?
Oh, yeah, I forgot about that.
Does anyone wish to speak on the matter in third reading? Thank you. The appeal is called for. Members are invited to return to their seats. Now ask the greffier to open the voting. If all members have had the opportunity of casting their votes, I ask the greffier to close the voting. That the draft law has been adopted unanimously in third reading, 44 votes for. The next item is the draft alcohol licensing law lodged by the Minister for Sustainable Economic Development. The main respondent is the chair of the Economic and International Affairs Scrutiny Panel, and I ask the greffier to read the citation.
Draft Alcohol Licensing Jersey Law 2000, a law to make new provisions regulating the sale and consumption of alcohol, to amend and rename the Gambling Commission Jersey Law 2010, to make minor amendments to the Gambling Law 2012, and for connected purposes. The States, subject to the sanction of His Most Excellent Majesty and Council, have adopted the following law.
Minister.
Sir.
Sorry, sir.
Yes.
Before we start, may I make a declaration?
Yes, of course.
I am the holder of a gambling licence, and I know this does not directly affect the alcohol licences, but they will be joining the Gambling Commission. I'd just like to make that clear to you, sir.
Thank you very much. Minister.
Thank you, sir. Sir, it's a real pleasure to bring this draft alcohol licensing law to the Assembly today. It's also a pleasure, sir, to say that my understanding is, and I'm pleased the Chair has just walked in, that before the second reading, the scrutiny panel are going to be calling this in for review. And I think that's absolutely the right thing to do, because I think as a States Assembly, sir, we have an opportunity to, it's a once-in-a-half-century opportunity to amend the alcohol licensing law so that it is fit for purpose in the modern world. But there is, as many members will know, and there has been a difference of opinion from the Comité de Connétable, which is their right, and I am pleased, sir, that I feel it is appropriate parliamentary process and appropriate for the States Assembly to decide that difference of opinion, and going through scrutiny in the appropriate parliamentary process is really the right way to do that, rather than here on the floor of the Assembly today, particularly when so little consultation was done with regard to the Connétable's amendment. So, sir, I'm pleased that I am introducing this as the principles in the first reading, and in this speech today, sir, I will be asking all members, Connétables, deputies, to support the principles and to leave the discussion about the administration of the law to another day. So why should States members support this law? Or ma'am, I should say. Ma'am, this law makes life simpler. It provides certainty to businesses and other organisations. It makes it fairer. And most importantly, ma'am, this law brings alcohol policy to the purview of this Assembly. So for the first time in history, Jersey's alcohol licensing policies will be democratically decided by a democratically elected Assembly in the States Assembly. And that answers, ma'am, a proposition from Deputy Ash, I believe back in 2021, which asked for that to be done and was supported strongly by this Assembly. The law, just reading through the main features of the law provides for a single independent regulator operating at arm's length and providing consistent island-wide decision-making, something which industry has long asked for. It provides a clear, simplified licence categories aligned with how modern hospitality businesses actually operate. It preserves the existing role of the parishes and actually provides the parishes with new powers, as it does for the police and the fire service. It provides for a faster, more predictable application process that reduces time, cost and uncertainty. It allows for the transparent publication of licences and conditions, improving clarity for businesses, residents and enforcement. It's proportionate. The civil-based enforcement addresses issues quickly without criminalising compliant operators. And it creates a fee structure that is far more fair, transparent and proportionate to scale and usage, resulting in no significant increase for businesses and in many cases a reduction. And unlike some of the commentary that has gone before, under this proposed law, the Alcohol and Gambling Commission will not be setting its own fees. That will remain the purview of the Minister. Because that is an order-making power that will come before the states that can be called in. I think it's appropriate that it's an order-making power rather than a regulatory power, because fees by regulations are a problem that many laws suffer from. But at no point will the Gambling Commission be setting its own fees. Ma'am, you'll no doubt be aware that this is not the first time the states have considered reforming alcohol licensing. Successive governments have attempted to reform this law without success. In developing the legislation before the states today, we have relied heavily upon previous work and past experience to develop a single, streamlined law. I'm grateful for everyone who has contributed to feedback during the law drafting process. Many, many people have been involved. This is a multi-year project which has seen consultation ongoing since 2024 with dozens of people and organisations involved in that. including the Comité de Connétable, the police, public health, the fire service. Key stakeholders have all been involved in deciding this law. The law provides for, I believe we found the right mechanism to ensure that government and the Assembly can direct alcohol policy according to the priorities of the Assembly. The law provides for faster applications, more flexible and proportionate enforcement, and removes unnecessary red tape. The core aim of the new law is to make it an enabling one, which allows businesses to obtain licenses that suit their operations in a timely manner. It will also bring the control of licensing and related policy matters into the hands of government and this Assembly. The regime under the new alcohol licensing law would look similar to this current position, but with some important changes. Now, I understand, and we see this from the amendment laid by the Comité, it is the administration of the law which is proving to be the point of discussion and debate, which is, a shame on the one hand because it's the administration, but the good side is that the principles appear to be something that we are all aligned upon. But I will first of all talk about the planned licensing assembly as planned in this law. But as I said, that is not the part that is to be discussed in the second reading rather than now. The role of the licensing assembly as drafted in this law has been replaced by the Gambling Commission, which will be renamed the Alcohol and Gambling Commission. The reason we have done this is because it achieves a number of things. It ensures we keep the consistency of approach across the island and between parishes. It will speed up the licensing process. Rather than licensees waiting for a meeting of the licensing assembly, decisions will be made in real time all 52 weeks of the year. It will create a clear appeals process with appeals able to be referred to the court, which for the first time will be separate from the body that has provided the license, whereas the situation we have today is that the court determines whether a license will be granted in the first instance and then determines the appeal. When I say the court, I mean the licensing assembly as part of the Royal Court. And most importantly, it will enable the government and this assembly to shape policy, to instruct how the law is to be enforced, and to advise what conditions should be attached to licenses. The process will also be digitised and the administration greatly simplified, with the Commission handling and centralising all of the information to be submitted. This will be far better than the current situation where, especially for businesses with premises in multiple parishes, there are a number of different stakeholders to be engaged, often requiring the same information to be submitted and shared multiple times. Under the proposed new regime, businesses would only need to submit information once to the Alcohol and Gambling Commission, who would then do the liaising with other stakeholders, including the parishes and the States of Jersey Police. With regard to policy, ma'am, any guidance which the Minister intends to provide to the Commission will first need to be approved by the Assembly. For example, the draft law retains the requirement that licences may only be provided to an individual who is a fit and proper person. Whereas this is currently up to the courts to determine, the intention is to bring forward a definition to make this far more transparent. In this case, such a definition could mean someone who has completed a relevant industry qualification, for example, holds a basic first aid qualification, has had a DBS check, who has been interviewed by the relevant parish. These are all just things that the new policy could put into such a definition of a fit and proper person. Members may disagree with that definition or may wish to see things added or removed. That's the virtue of this law. Members can change these things. This law doesn't set our alcohol policy in stone. It allows future governments to take a flexible approach and to make targeted interventions where they are needed. But it brings that power into the hands of this Assembly. In addition to reforming how decisions are made and informed, this law also removes old provisions. Businesses won't be required to have a physical copy of the law printed out to be kept behind the bar anymore, but they will have to publish their price lists, but a digital copy will be acceptable. Licensees won't need to manually renew their permit every year. Restrictions on residency status will be brought into line with the Control of Housing and Work law, so a person who is in Jersey legally can't be denied a licence simply because they haven't spent the last 3 years in the EU or the Commonwealth. And businesses will no longer need to hold multiple overlapping licences for the same premise. Instead, licences will be bespoke and issued in accordance with the alcohol guidance that this Assembly approves. one of the reasons this is important is that various premises in Jersey have to have multiple licenses just because of the way the premises are designed, not for any other reason. There is a fairly well-known example where one premise in Jersey has a corridor that has to have its own separate license because it joins two different areas of the premise, a bar with a nightclub, and therefore a corridor has had to be awarded a license. This means rather than the current 7 different categories of license, the new law will have 3. It will have an on license, it will have an off license, and it will have a temporary events license. Far, far simpler and far easier to understand. With regard to fees, ma'am, this change will also allow us to simplify the fee model. This will help us to create greater fairness. For example, businesses will no longer need to complete several applications and pay separate fees just to operate a bar within their restaurant or to provide a takeaway service. Under the current model, for instance, there is one supermarket that pays £114 for each of their supermarkets, totalling £342. A medium-sized hotel is paying nearly 10 times that in licence fees. One well-known cafe, Beresford Street Kitchen, pays nearly 5 times what a very large supermarket pays in Jersey today. So it shows that today's fee model is completely out of kilter with the reality. This is not fair and doesn't reflect either the cost of enforcement or the impact that each establishment makes to levels of drinking in the island, particularly at a time when we would prefer to see people drinking in licensed premises rather than behind closed doors at home. Ma'am, I want to be clear that none of this means that fees will automatically rise. By using an already established regulator, costs will be low, and we will not be increasing the total fee income beyond where it stands now. The fee envelope of £260,000 remains exactly the same. All we're doing is shifting the burden from those smaller enterprises to the larger ones. Those enterprises have been consulted on that. They understand the need for the changes, and that they, whether they're supermarkets or cafes, have bought into that. With regard to the parishes, I made it very clear when I set out on this road 3-4 years ago that I did not want to see the role of the parishes diminished in any way, and that is the case with this law. I won't go into detail about the Comitee's amendment, as we'll cover that in a later debate, but I will emphasise again that the parish roles will not change, except to be enhanced. Alongside the States of Jersey Police, one new power that the parishes will get is new enforcement powers. New powers to review the legislation, and they will also be included in the proposed ministerial oversight group so that they are able to input on any proposed guidance from day one. Sir, the parishes have been regularly briefed on this process and understand how it will affect them. Before we launched our full public consultation in December 2024, before even we briefed the bailiff, sir, and his predecessor at the end of November 2024, we began this process by setting out our proposals, including the Gambling Commission, to the parishes. With regard to the need to change, ma'am, the current licensing law is the same age as I am. And although some members, probably too young to recall, much has changed in the hospitality industry since the early 1970s. We've seen changing drinking habits, particularly amongst our younger islanders. We've seen new business practices which have struggled to navigate the existing law. And we've seen online sales which were not even anticipated in the existing 1974 law. The new law takes all of this into account. It's a law that is ready to be fit for purpose for the next 50 years, and that can evolve through the use of policy, which will remain in the hands of government and this Assembly. It is designed to be flexible and enable not only businesses, but the needs of future governments, parishes, our public health considerations, and our enforcement agencies' considerations to be taken into account. This is genuinely a fantastic opportunity for the States Assembly to show how it, as a whole, working together, we can break down some of the barriers to business in this island, how we can give a vote of confidence to our hospitality industry in this island, which has been suffering some tough years, particularly since COVID. And so, ma'am, with the view to putting forward this proposition in the first reading, to have the principles voted on, I do ask all members to fully support the principles, to enable scrutiny to go off and do their work with the full 4 sittings at their disposal to do that, so they can look at the Connotabs Amendment, look at the proposal that I have lodged, but also to look at any other potential routes for the administration of this system. I think it would be incredibly sad to stop this going forward to that second reading just for the sake of a part of the law which is about the administration. I think all parties, including the parishes, are content with the idea of the policy and the licences, the real key parts of this. And we just need to work out the way forward on the administration of the system, and we'll be able to bring this back, hopefully, at the end of 4 sittings. And so I do ask all members to strongly support the principles and then allow the parliamentary process to take its time, ma'am. Thank you, and I urge support for this motion.
Ma'am, may I ask for a point of clarification, please?
Are you willing to give way for a point of clarification?
May I also ask for a point of clarification, please, Mark? Thank you.
Absolutely.
So I'd like the Minister to confirm why he's seeking to speak for my panel by saying that we're going to call this in, where he got that information from, because we've not decided to call this in. I think our position is that we want to listen to the debate, and I'm slightly put out that he seeks to speak on behalf of the panel. Could he confirm his comments?
Absolutely. It was my understanding from my last meeting on Monday, so I apologise profusely if I got that wrong. It was totally unintentional. I understood from our meeting on Monday that it was going to be called in, and that's where I got that from. I didn't feel that I was speaking on behalf of the panel. I felt I was passing on information that I gained on Monday. I personally would like the scrutiny panel to call this in. I think that would be incredibly helpful to the whole Assembly. Thank you, ma'am.
Thank you, Ma'am. Just a point of clarification for the Minister, please. In his speech, he said, "At no time will the Gambling Commission be setting its own fees." Now, I presume that's under Article 9, but when he gave the briefing to members, and I asked him the specific question, he said that they would determine the fees for the alcohol licensing, but would not determine the fees for the gambling licenses. Could I have just confirmation and clarification of that aspect? Thank you, sir.
You able to clarify?
Absolutely, ma'am. In my speech here, I'm talking about alcohol licensing. I'm not talking about gambling fees. This is solely about alcohol licensing, and that is what I was referring to in this. The gambling one of the views that has been put forward is that the new Alcohol and Gambling Commission will put fees up. What I'm saying is the Alcohol and Gambling Commission cannot decide its fees with regard to alcohol licence fees. They are decided by the Minister, who will do that by order and place that order before this Assembly for 14 days, as is the normal process, and any member would be able to call that in should they be unhappy with those proposed fees. So my point is that the Alcohol and Gambling Commission will not be setting alcohol licence fees and therefore cannot put those licence fees up.
Very well. Are the principles seconded? Deputy Kovac, I understand you wish to make a declaration of interest. Is that correct?
Yes, I want to declare that my husband is a holder of an alcohol license for for our restaurant.
Myself as well.
Same. We have one alcohol license on one of our cafes as well. Declaring interest in that.
Deputy Ward, the Constable St Clement, you making this?
Yes, I need to make a declaration. I have 2 businesses with alcohol licenses, so I need to declare that and have a ruling from you whether I can take part in the debate or not.
I think you are able to take part in this debate because there's no pecuniary interest to be gained from you participating. Deputy Curtis, do you also want to make
Could I declare I have one business that has a licence under the 1974 law?
Thank you. There are a number of members who have already indicated that they wish to speak. I'll read them out so members know in advance where they are in the pecking order. First up, I have Deputy Scott, then Deputy Curtis, Deputy Balash, Deputy Ayer, the Constable of St Helier, the Constable of St Clement, and then Deputy Wall. So starting with Deputy Scott.
Sorry, Ma'am, mine was for the clarification.
Fine,
Thank you.
I'll delete you then, Deputy Ayer.
Mine as well, ma'am.
Ma'am, I asked online.
Sorry, I didn't catch that, sorry.
I have put request online to speak, please.
Thank you, Deputy Gardner. I'll add you to the list. So starting with Deputy Scott.
Thank you, ma'am. I don't really want to add much to what the Minister has said about the reasons for bringing this law, partly constitutional, partly to reduce red tape, to support the alcohol, to support the hospitality industry, all those things. The point I want to home in on, because I think that it's relevant to the amendment that's been brought by the constables, who I have generally admired in terms of alerting the Assembly to constitutional issues. The point I want to emphasise is the regulatory one. I believe that part of the controversy that's been kind of associated with this law has been the identification of the Gambling Commission as an appropriate body to regulate under this law. And I'm saying this because in the course of the work, and I believe that within this States Assembly there's been a few teasers from my report on the Ombudsman, but one thing that's come out has been in the area of complaints and really distinguishing between what kind of complaints can be pursued, how, and what's really appropriate. And in this kind of respect, I do want to say that there needs to be a clear distinction between regulatory decisions and how regulatory authorities perform, and what the public should expect in this regard, and why that might be distinguished from more general administrative roles. I'm aware that the parishes do administer certain things, and in some respect, licences are involved. You might say that issuing licences is regulation, although we know that when it comes to the regulating of dogs, well, perhaps there's some more work to be done, perhaps there's some more enforcement to be done. I also want to let members know that I have asked quite a few questions of the Gambling Commission to satisfy myself that it could be an appropriate regulatory authority. Because I'm very conscious that some people in this Assembly almost have got a kind of knee-jerk reaction to the idea of arm's length authorities. They will be runaway trains. They will cost lots of money. Never mind that some parts of this administration, I don't mean to name names, but we've got non-ministerial departments, we've got the government itself, also have issues, I believe, when it comes to the controlling of costs, which means that overall, there's a lot of work to be done in terms of financial management. And I do believe that there have been some, let's just say, you know, some sort of protocols, some sort of processes that perhaps haven't been ideal here. They do need to be worked on. But simply saying, oh, you're going to involve an arm's length organisation and we don't like them because we think they're runaway trains, I don't think is reasonable thinking. I think it is it's not really focusing on what's at the heart of the issue there. So I come back to the Gambling Commission because I have asked them questions about the manner in which they regulate, because I think they should be asked questions. And I'm not sure who else has asked them questions about how they regulate. And I've asked them for certain things. That includes things like their complaints handling process, which they have produced to me. And I actually thought that it was a lot better quality than some I have seen. And in fact, I'm aware of one so-called regulator who didn't even have one, and well, let's say that's been alerted to the relevant minister, along with some associated problems there. I've also asked for things like how it makes decisions. You know, it actually has got rules about how it does its decision-making. I asked a lot of regulators about this, actually. because I have found that there are people making decisions who don't have these rules. Now, you know, you expect justice, you expect fair treatment when you deal with regulators. And that's where the courts actually have a key role to play in this society, because they follow very, very well-crafted rules in terms of decision-making, and that can be appealed onto high courts, all that sort of thing. So it's really important that we've got a clear understanding about what rules they apply when they make decisions. And I have that document. You can ask for that document. And I don't actually think it's a bad document, and believe me, I'm not the useless. I do tend to go into things in depth. And then the code of conduct, of course, that's really important. So all of these things, and I've been doing a lot of this actually around the whole complaint and regulatory landscape, as I've tried to understand what is it that people need to actually engage with in order to ensure that they have their business handled, decisions made in what I can feel comfortable with as a States member, and feel, yes, you know, I think that's appropriate. And I think that there is a sort of chain of ultimate kind of accountability and things that, you know, that us as States members can perhaps in ourselves challenge. And, you know, it's not always easy when you've got things in different constitutional areas. So I don't know whether or not the scrutiny panel will be calling this in, it is very much their decision. But should they call it in, I would very much ask them to consider these issues. And if they don't, I would ask States members to do so and to approve the principles. And I indeed am happy in approving the whole law. Thank you, sir.
Deputy Balash. Oh, sorry, Deputy Curtis, I misunderstood. I thought that you were making your declaration of interest. You want to speak as well. Sorry, apologies. Deputy Curtis first.
Thank you, Ma'am. No, I wanted to get the declaration in earlier, but the light was for a speech. I've made my first declaration, Ma'am. My second one is more personal. It is that I have a deep care about a well-functioning hospitality sector, and I think that's one far more members in this Assembly can share a declaration for. I will take a few minutes on this, closer to the 15 than 5, if members are looking at the doors. But the first place to start is that in looking at alcohol licensing and the conditioning of hospitality premises in particular, we should ensure that we keep an eye on the fact that islanders and visitors who go to these licensed sites do so for all manners of hospitality. An alcoholic drink is one, sure, but this is just part of the picture. For some licence holders, alcohol is a very small part of their trade, like cafes hoping to slightly diversify their offering. For others, it forms a slightly greater part, such as restaurants. But many still frequent these, pubs, clubs and hotels included, without ever purchasing an alcoholic drink. How we regulate these spaces because they serve alcohol impacts every user, and we must bear that in mind. Turning to this part of the debate, the principles, I do think there are some key questions we should ask, and I will work through them in turn. The Minister has been keen to stick to the principles, but I think it is not beyond us to have to discuss administration and other matters within this as they form a key element of modernising the law in his view. Those I want us to talk about are, first, does the law need changing? How does it need changing? And is one of them to actually deliver a more vibrant hospitality sector? How will the law achieve this, if indeed it does? Is the new proposed regulator set up for success to achieve this? And are there any other risks in this legislation? First, does the law need changing? The simple answer to that is yes. I think the Minister gave a few examples. The existing law is showing its age in several areas, such as policy making not sitting with the Assembly, although that may be a double-edged sword, and the complexity of licence categories. Other areas are minor, but could easily be changed, such as, highlighted, the definition of a fit and proper person requiring 3 years residency or a reference from someone in the trade where they lived prior and restrictions on where that was. Other areas are perhaps not ideal, but they do serve a time and cost-efficient system. That includes quarterly licensing assemblies. They inherently save time, they group work together, and in reality those who follow court listings will note that extraordinary licensing assemblies dealing with matters often occur when those matters require more rapid resolution. The system has shown flexibility. Much might be made that the current system rests in the courts, but short of the licence categories and policy direction, the existing system is well established and businesses continue to trade across all hospitality sectors. Members will no doubt have their own small examples. The law could benefit from change, the extent to which is what we should debate as well. But how does it need changing? And we have to ask what it wants to achieve, not just through administrative process improvements, but we must look to the feeling on the street and the reality in venues. To this, the Minister should be more visionary in explaining to members what the hospitality sector could look like should we approve these changes. Are there venues that cannot exist under the existing law that will now be made possible, save for the events and movable bars the law covers under the third category offered? Will opening hours change to encourage calmer late night spaces? Is there an emergent policy direction to assure members that we are signing up to a principle we agree? Or are we at risk of a draconian policy emergent, albeit requiring approval from the Assembly? And the Minister points to flexibility and policy being directed by the Assembly. But are there safeguards in place that give venues confidence that they continue to trade as before and not see key features such as their opening hours or conditions of trade change assembly by assembly, where they have known consistency for decades? In particular, could the Minister address how the former taverners and club licences will exist in the new legislation? Previously, a taverner's first category licence permitted sale from a bar rather than table service. It's fair to say we've seen a shift in the emergence of more hybrid venues, where the tone is less than that of a tavern, and it's a shame to lose that word, but it makes perfect sense to go and purchase one's own drink from a counter. How do conditions in practice under this legislation achieve that balance of self-service at a bar, and we, how does that differ to the reality we see that many traders almost perform this under third category licences now? The 1974 law defined a public bar by virtue of being a first category taverner's licence. One would buy at a bar and be able to stand at it. The new law removes this explicit definition with one that must be defined by the Commission. Where does this really create uncertainty at this stage? Secondly, how will clubs be managed in this model? Not just existing clubs whose conditions may be more simply mapped from the old law, but to new clubs who now face a blank slate, perhaps carving out a bespoke range of conditions and requirements, the length of which we do not know. Is it simplicity? And it may well be, but currently we do not know. Ma'am, if process and simplicity is the main aim, there is a risk that this draft legislation proposes too many changes to achieve the desired result, and it is on the Minister to assure us that it is proportionate. Before turning to the second element in this legislation, the principle of amending the Gambling Commission and forming the Alcohol and Gambling Commission, it might be worth framing the scale of the licensing, which I couldn't find in the report, although the Minister has now shared income is circa £260,000. The most up-to-date data I could find on this to assist members was a full list of licences published in 2024 by FOI. It does show, however, that licences are transparent at the moment and that the new system does not deliver technically greater transparency. From this, I've compiled the following statistics. 566 locations held licences. Across these, 734 licences were held. 365 sites held one or more licences. Of these, there were 143 first category taverners licences, 25 residential licences, 252 restaurant licences, 23 comprehensive licences, and 30 club licences. There were 233 off licences, 37 of which were held by venues that held one or more on licence. This is helpful in understanding the scale of licensing. At this point, when I wrote this, Ma'am, I said we didn't know the current revenue generated by these licences, nor the workforce, including courts, currently used to provide the existing service. We do not know whether what is proposed by this amended commission will require greater or lesser staffing than the current system. The Minister is assuring us this is a simpler and more responsive system, and it would be good to see this reflected in leaner staffing, or the same, not more. The Minister has published some very draft numbers on licence fees for venues, and I did my own calculations showing that the on licences would generate £182,500, off licences would generate a range. The short of it, now the Minister has given us the data, is that my prediction of £250,000 income per year is 10,000 off what's current, so I'm pretty glad that the numbers stack up from both sides. But the Minister does need to confirm that he has understood the staffing levels he thinks the Gambling Commission will operate at, and whether he has any, or to what extent, confidence that the amended Commission will deliver its function within this. If there is a risk that the draft and very draft fees published could be higher than published, the principle of the law may not achieve its aim. I believe one principle of the law should be not to increase financial burden on businesses. Given we are approving a commission with no enactment day costs or staffing, we need that information. And the Minister has guaranteed that this is a fairer system, but I should point out the proposed licensing structure would see some businesses increase in their fees from £114 to £500, namely those being off licences of a square meterage of greater than 50 square metres. Many off licences hold it for only a very small fraction of their businesses. Garden centres come to mind. And this is a huge increase the Minister must think about when he describes this as fair. In respect of the Commission, there are further questions to be asked. None of these are meant against the Commission. But if we were to hand a new function to a body and as such amend it, I believe we should only do so when we are satisfied it is the best body to deliver this. A read of the 2024 annual report shows the current Commission generates a turnover of £859,000, worth comparing to the £260,000 revenue that will be given to it for alcohol licensing. Staff salaries, including pensions, £478,000, and fees to the 3 commissioners that year were £80,400. The accounts for previous year and previous years before that do not provide any further breakdown, pretty much, on expenditure such as rent, CEO pay and commissioner pay, all things we expect from bodies that provide functions, and transparency we see from bodies like our utilities and our arm's length organisations. Before we provide new revenue service to a body, we must ensure their accounting is transparent. Tenure of commissioners is also not in line with the practice of many other organisations. Commissioners can be appointed for 5 years at a time, the lower limit removed by these laws, and this does not align with more common best practice of 3-year terms, and the 10-year maximum does not align with maximum periods of 9 years. These are not addressed in this law. It is not clear to me on who makes the decisions on licences and practice. Is it, as in all likelihood, the Commission staff, or do Commissioners convene to form an assembly themselves? Under the current system, decisions on conditions and the debate therein happens at publicly attendable licensing assemblies. This appears to be lost, and it isn't clear how a neighbour or interested party may make submissions to the Commission on a statutory footing in the same way one who speaks at a parish assembly can then address the licensing assembly. One more thing, as we've heard now, is that the Commission will have a dual fee model, gambling fees set by the Commission under their law, with many thousands of pounds per licence typically, and alcohol fees set by the Minister by order. Each must cover their own respective costs, but at the same time it must only be expected that to achieve efficiencies, resource at the Commission will be shared between both functions. The principle of this dual setting isn't addressed. Lastly, risks beyond those stated. The first, I would argue, is obvious. The existing system is well understood and, short of some niggles and quirks, operates well and has fostered a to-date robust hospitality scene, something not all regions can support and say they have. Changes would introduce a new body, move the complexity of categories into the complexity of conditions, to name a few. Those could all be addressed and could be genuine simplifications, but we are taking a giant leap of faith in how the law is written, the detail the Minister gives in his report. But then there are more fundamental ones. The law introduces wide-ranging new enforcement powers. Most challenging of those, I think, are civil penalties. The starting point in enforcement should be to ask whether the sector is well regulated and well managed to date. I would like to think members agree we have a well-functioning, well-managed industry. Serious challenges are rare, observing guidance is high, We can just look at how seriously the industry took the decades-long ban on drinks promotions, and that was honoured. And issues with licences are dealt with by parishes and the licensing assembly. Constables may wish to talk about how they are able to deal with matters already. Rather than retain existing powers, civil penalties add a further level of complexity rather than simplicity. By default, penalties would be receivable by the Commission, and only through a raft of orders would fix the scope of their use and limit amounts. This does not appear simple to me. If civil penalties should remain, and I don't think they should, payment should be to general revenue of government to ensure separation of concerns in applying those any fees. Ma'am, to summarise, despite that 13 minutes of speaking, I'm not against the principles and I will be supporting them at their highest level. But at this time, I don't think we have the information in front of us to vote on the articles, and I don't think it's just on scrutiny to provide that information. In particular, I ask, and to summarise from the Minister, clarity on how on-licence conditions will enable appropriate operation of various types of venues, including clubs and public bars, whether the Alcohol Policy Group should have guiding principles and statute to provide a statutory steer in primary legislation and avoid instability in policy that would affect businesses trading, staffing requirements and the forecast cost requirements, including whether fees are truly fair before we choose the regulator. The operation of the Commission, the recourse and statutory rights of interested parties, and the suitability of the body as configured now. Then the need for more numerous enforcement routes, including civil penalties. But last, and perhaps most importantly, how this law will truly improve and enable a hospitality sector for all, and what that might just look like.
Thank you, Deputy. Deputy Balash.
Thank you, Ma'am. I hope that the scrutiny panel will call this law in, because I think there are important issues for consideration. There are obviously, and Deputy Curtis has mentioned them, important changes that are made by the proposed law, including the shrinking of the number of different licenses, the taking in of policy development and policy articulation to ministers and to the Assembly. And there are a number of other good things in the law as well. But I have two particular reservations. The first is that no compelling reason, in my view, has been given for the abolition of the Licensing Assembly. The Licensing Assembly is not a court, even if it is composed of the same people. It is an administrative body. Members don't robe. It has an entirely different feel from the court, and decisions of the Licensing Assembly can, of course, be judicially reviewed by the court. It works well. The jurats are experienced in reaching difficult decisions, balancing competing interests, reaching fair judgments on controversial issues. Perhaps the Gambling Commission will be up to it as well, but they certainly lack the experience of the jurats. The Minister spoke of a speedier process, but I must say I have some doubt about that. Exactly the same reports from the Chief Fire Officer, from the police, from the Public Health Department will be required. It will still be required. Applications will still go to the Parish Assembly. The bureaucracy attached to the granting of licenses will be much the same. The only difference will be the body which ultimately gives the decision. So my question really is why try to fix something that ain't broke? The second point relates to the first, in that has always been in the licensing assembly a subliminal tension between the interests of commerce and the interests of public health. Businesses want to sell more alcohol because there's more profit in it. There's no secret in that, and there's nothing wrong with that either. That's the nature of business. On the other hand, however, public health officials seek to moderate consumption of alcohol. I don't have the figures available for me at the moment, but in Jersey, I am confident that we consume considerably more alcohol than in most other places and come close to the bottom of various scales in that respect. And that has consequences for public health. Perhaps one of the health ministers will speak to this during the course of the debate. The draft law gives the Minister of Economic Development exclusive responsibility for giving guidance and directions to the Commission. This is new. Now, I appreciate that the Minister is obliged to consult with other ministers in the policy ministerial group, but the person who actually gives the guidance upon which the Commission will be bound to act is the Minister for Economic Development. As I say, this is different. It's not surprising, in my view, that the licensed trade has welcomed the draft law with enthusiasm. The Commission, as I say, takes guidance from the Economic Development Minister, but does not take any guidance from the Medical Officer of Health. How the Commission will approach the task of granting licenses will be different from the approach of the licensing assembly. I have one other observation that I might make in the hope that it might be taken into account if the law is called in by the scrutiny panel, and that is this rather curious creation of a licensing appeals court, which is actually the Royal Court. I don't understand why it is necessary to include this nomenclature in the law. Much more straightforward and understandable to refer to an appeal to the Royal Court.
Councillor Hellier.
Thank you, ma'am. It's been very interesting listening to the opening speeches, and the phrase "it ain't broke" or "is it broke" has been used at least once. I particularly value Deputy Alex Curtis's searching questions about the industry and his points about the industry and his questions about the proposed new law. Ma'am, I've been chairing the parish assemblies, licensing assemblies. I've been attending the licensing bench in the Royal Court for nearly 25 years. And if I can perhaps pick up on the opening speeches, I have to say that the system works really well. It works well from the point of view of being responsive. There are frequent extra assemblies called when a licensee forgets to renew their license, or other entrants want to come into the business. The parishes do a lot of the legwork, and not just holding the assembly, but parish office officials examine the premises that are due to be licensed. And in the case of St Helier, which holds roughly half of the several hundred licenses in the island, that involves my officers in a great deal of work, and they are extremely experienced because they have been doing it for so long. They know what to look for. The other statutory consultees, the fire service, environmental health, they also are extremely scrupulous. Their reports go to the parish, they're run past the prospective licensees. The licensing bench, when it goes to into the Royal Court, is sure to make sure that these things are being followed up. One of the, I think, interesting safeguards that the current system provides is that where a parish assembly has been stacked, if I could use that word, it has been known to happen. A licensee is very keen to get their proposal through. They have heard that there might be nearby residents concerned about the particular license, and so they bring all their friends and relations who have the right to vote to the parish assembly. And the ability of the parish assembly to function in this way, of course, is something which is a matter for another day. And I know that a review of the role of the parish assembly is underway. But again, in nearly 25 years of chairing these meetings, there have occasionally been times when an assembly has been persuaded by the sheer numbers of people coming to approve something which clearly has concerned residents. And I've always been reassured by the fact that the licensing bench, when it gets to them, they know that. They pick up on it. They invite concerned residents to speak. And it works both ways, because the licensing bench, having the final say, is both there to protect the residents of the parishes from potential nuisance, particularly where a license may involve loud music, for example, or lots of traffic. But they're also there to protect the licensee, whose very legitimate application has been turned down because a group of sort of not in my backyard kind of protesters has turned down the license. I can think of several licenses where I thought they're perfectly reasonable, my staff have thought they're reasonable, they've been voted down in the parish assembly, and along comes the licensing bench and said there is nothing wrong with this, and they've given it a license. So the system works in that way. It works really well. I did also want to point out that we have an extraordinarily successful hospitality industry in respect of licenses. And when you think of the changes that have taken place in Jersey in the last 50 years, quite good changes in the sense that you can no longer drive back from Latac having had several beers, and of course lots of other changes. The great increase in cost of having a drink on licensed premises. So many changes have happened, and yet in St Helier at least we see new licensed premises opening almost every week, and it's a testament to the resilience of the industry, the adaptability of the industry, the vigor of the industry, that so many people are putting their time and money, importantly, into opening new licensed premises. And Jersey is, I think, so lucky, so fortunate to have the hospitality industry that we do. So to say that somehow the licensing regime is stopping that isn't really borne out by the facts. The facts are that we have a very, very successful licensing trade. Hospitality, in spite of all the problems, is doing, I believe, really well in Jersey. The Minister in his opening remarks, he sort of steered away from, he did use the word controversy, I think the Assistant Minister used the word controversy, and the Minister suggested that there'd been an absence of consultation in the Comitee's amendments. That isn't borne out by the facts. As the Minister acknowledged, the changes to licensing have been talked about and researched, and previous bodies have tried to bring them through. There has been a lot of consultation. It is not true to say, as some have said recently, that there's been no consultation with the industry. And indeed, the concern of the Comité that putting the administration of this function in the unlikely arms of the Gambling Commission The committee has been saying for quite a long time that the parishes are already doing the lion's share of this work. Why would you hand this role to somebody who, on the face of it, has really nothing to do with licensing at all? The only link I can find between gambling and alcohol licensing is that when we drink, we gamble with our health. The parish system is, of course, extremely transparent. One of the great things about the parish role is that every year, parishioners, ratepayers, get the chance to scrutinise the constable's accounts and to change them, to change the budget if they wish to. I've said before in this assembly that if the taxpayer had the same ability to put the States of Jersey and the Treasury Minister in the dock, if you like, to say, why are we paying this money for this particular thing? Let's cut income tax because you don't need that money, Treasury Minister. I suspect we'd be paying lower tax than we do at the moment, but that's another matter entirely. I'm certainly not convinced that what is being proposed is in the best interest of the island. In a way, it doesn't matter because we know that nothing is going to happen anyway for at least a year because the alcohol policy has got to be developed and brought back to the States. So in some ways, this whole debate is a little premature because there's a lot more work to be done. There are all the questions that Deputy Curtis raised and others that I'm sure will be raised that need to be answered. So I'm not going to get too concerned about the outcome of this. I do think it should go to scrutiny because I think there's a lot of work that needs to be done. But for me, the key question remains, is the current system doing such a bad job that it is not fit for purpose? And if it is going to be replaced, why not take the opportunity to enhance the role of the parishes? The Minister says that it will be enhanced by these proposals, but it could be enhanced a jolly sight more if the Gambling Commission wasn't involved and if the parishes were to be given even more responsibility. And I refer members back to the administration of welfare. I mean, until, I forget what the date was, 2008, I think, the parishes did welfare, they administered welfare. And we then passed that matter onto the states. And again, I'm not going to get into that because I don't want to set lots of hairs running. But with the benefit of hindsight, I wish that I had argued that the administration of welfare should stay with the parishes and the funding of it should go to the centre, to the government, because I think that would have cost less and I think it would have delivered a more responsive welfare system than we have at the moment. But that's, as I say, not technically relevant. What I am concerned about is that the more that is taken away from the parishes, what will go next? We already know that there are those who would like to take away firearms administration from the parishes. I think we should be growing the role of the parishes and not weakening it. And so I would ask members to think very carefully before they support the principles. Thank you, Ma'am.
Ma'am, point of clarification, please.
We're going to give way, Conatable.
No, Madam, I've made my speech. Thank you.
Conatable of St Clement, I had you on my list, but was that simply to make a declaration of interest? Lovely. Then the next person to speak should be Deputy Wall. Oh, was yours to make a declaration? We're doing well. Deputy Gardner.
Thank you, ma'am. And I'm pleased to follow my constable. And I would really be grateful. I was grateful for Deputy Curtis' speech because he raised lots of points that I put in mine, so I don't need to duplicate. And let me begin to saying it clearly. I think we do have a broad agreement that the current licenses law needs to be updated. The system complex, outdated, frustrating sometimes for businesses and administrators alike. So reform is necessary and it is welcome. As the Minister mentioned in his speech, the question before us is not whether to reform, but how we do so. And for me, follow my Constable of St Heliers speech, It's the relationship between local communities, government, and industry. It's not the reform, it's about the proposed structure where I have concerns and concerns were raised, and what is most effective and proportionate way of achieving it. I believe the concerns which I heard, they are practical rather than ideological. And they basically relate to the decisions, how they will be made, by whom they will be made, how local information will be taken into account, how system will operate day to day for applicants and communities. And obviously, if the Gambling or Alcohol and Gambling Commissioner is the right place. I also would like to acknowledge concerns raised by the Jersey Hospitality Association. They have emailed to us, and I do agree that businesses need licenses system that is predictable, timely, and consistent. Those concerns are valid and deserve to be taken seriously. Suggested clear state-approved guidance, transparency in decisions, and proper right of appeal can provide consistency while still allowing local context to be taken into account. And what matters most to the industry, I think, and I've heard Deputy Curtis, it's to understanding how decisions will be made, feel confident, and to be cost effective. Now, cost and fees, interesting that Deputy Curtis raised it through the numbers. When I wrote my speech, I thought, how if we operate Alcohol and Gambling Commissioner, that we don't, like I said, know exactly the cost, and it will be more work for them, and it will need to pass through several systems. It's, for me, just the common sense, it looks like that the cost might increase for the businesses. If the process can be managed entirely through the parishes, it should save. A parish administration, and Constable of St. Helier presented it really, really well, already deal with license accelerator scheme, have assemblies. It works, the process established, and it works well with the enforcement bodies. So if we are seriously thinking about proportionality and keeping costs down for businesses, that consideration should weigh heavily in our decision-making process. Now, going to the structure, and if members look, and I looked at the page 7 of the report accompanying the draft law. When I look at the page 7, and there is a table on page 7, when I look at this table, the question that I ask myself, why could this process not be delivered through the parishes in its entirety? Why do we need commission? So under the draft law, policy development sits with the ministerial group and States Assembly, appeals sits with the court, and clear guidance issued. So this element provides consistent oversight and accountability. And the table 7, there are 3 areas that parishes are not involved, and I believe that some of them parishes can be easily involved and can be a place where the decision is taking place and simplifying the system. So what the approach basically will mean, states level control over the policy, judicial oversight over appeals, and clear transparent framework for decision making which rests with the parishes. And this is why I really welcome Minister's openness work with the scrutiny, as a substantial piece of legislation which will affect applicants, regulators, enforcement body, and whole hospitality sector. And it's for the next 50 years or so, maybe more, and it's a half-century decision. I believe that really scrutiny is important, which will allow detailed examination how it will work and operate in practice, proper engagement with the committee, the CONATAP and hospitality industry, reassurance for all parties, and before the framework is finalized. So taking the time to do it properly should be seen as good governance and not delayed. So for these reasons, I would support principles and I welcome scrutiny if they decide to call it in, to ensure that the final law commands confidence across the island. Thank you.
Thank you, Deputy. Deputy Howell.
Thank you, Ma'am. I think I understand that the Minister has brought this proposition because he feels passionately that we do probably need updating of the law. It's 50 years old, and I can understand that. But unfortunately, having read it very carefully and listened to all the arguments we've had so far, unfortunately don't think that this law is quite ready for us to vote on it yet. Deputy Curtis has raised a great deal of questions. How unlicensed conditions will enable appropriate operation of various types of venues, including clubs and public bars, whether the alcohol policy group should have guiding principle in statute to provide a statutory steer and avoid instability in policy, which would affect businesses, staffing requirements of forecast costs, including whether fees are fair, operation of the Commission, the recourse of the statutory rights of interested parties, the suitability of the body. When did we decide that we, as an assembly, that it's a good idea to combine the Alcohol Commission with the Gambling Commission? I haven't had a say on that, sir, ma'am. My concern is that scrutiny of this would be rushed because of the timeline and the very heavy workload of legislation we will have to scrutinise at the end of this political term. So I'm on the strong view that I would like to call for more work for a reference back. Yes, thank you, sir. Oh, sorry, Mum. I'd like to, for all those various reasons that I've just mentioned, the reference back, and also the fact that I'd also like to the role of the parishes to be taken into consideration, because I think they do a very good job at the moment, and also the role of the court, because I think that needs to be looked at again. So whereas I think we probably do need to cut down on the number of categories, I do think this needs further work. Thank you, Mum.
Is the proposition for a reference back seconded? Before allowing a reference back, I need to ascertain what it is exactly that you're hoping to gain in terms of further information or the ambiguity or inconsistency in information which has been provided to the states. It's further information that you're seeking.
Yes, Ma'am, and also how it will actually work and how it will improve things for the alcohol licensing, and also whether we should be doing this through the Gambling Commission. Ma'am.
Looking at standing orders, Deputy, I think it is allowable. My concern was whether or not that to allow this would prevent the debate resuming at a future meeting. But given that we do still have 4 states meetings, and it would be possible potentially for the Minister to bring this back at the next meeting or the meeting after that, then I think that a debate on the reference back is allowable. So do you want to speak further now, or?
I think probably I've asked enough questions, Ma'am. Thank you.
Very well. Does any other member wish to speak on the debate for a reference back?
Sorry, Mum, can we just have a clear definition of what the reference back, because I was listening and I'm not entirely sure.
Well, the Deputy is seeking further information as to how this legislation would actually be applied in practice and the implications of that. which she feels have not been appropriately outlined by the Minister?
Ma'am, that is a very, very wide definition of what the Deputy is looking for. I do feel that definition needs to be somewhat refined, because how something will work is not something you can just bring back now.
Deputy Howell, can you assist?
Thank you, Ma'am. First of all, clarification on how on-licence conditions will enable appropriate operation of various types of venues, including for clubs and public bars. Number 2, whether the Alcohol Policy Group should have guiding principles in the statute to provide a statutory steer and avoid instability in policy that would affect businesses. 3, staffing requirements and forecast cost requirements, including whether fees are fair. 4, operation of the Commission, the recourse and statutory rights of interested parties and the suitability of the body. 5, the need for more numerous enforcement routes, including civil penalties. 5, the next one, how this law will truly improve and enable the hospitality sector at all. And the last one is the role of the parishes, which I believe has not been properly voiced in this legislation. And I think we have to be careful. We think we do need to change, but we have to be careful what we're changing and how we're doing it. Thank you, Ma'am.
Deputy Kovac.
Point of order,
Sorry.
if I may.
Yes.
Is it possible or appropriate to ask the chair of the panel whether he is planning to call this in? Because I think that might have bearing on members voting.
It's a matter for Deputy Tadia. I can list you to speak if, in this particular debate, because we have now moved on to the debate on the reference back. But it would be helpful, I think, to the Assembly to know if your panel is intending to call this in, because it does impact on the timing.
So I'll put my light on, but I think I'm not first in the queue. Thank you. To speak. I don't think I can, Ma'am. I don't think I can order. I can't answer a point of order, so that's for you, Ma'am. I've put my light on, and I will speak on this part of the debate. But I can speak earlier if members wish to give way for me to speak earlier.
I have listed to speak in this debate now Deputy Kovac and Deputy Scott. I don't know if any other members want to indicate that they wish to speak on the reference back. The Constable of St John and Deputy Renouf. Deputy Kovac.
Thank you, ma'am. I would also be interested to hear from the panel, and if others want to hear the panel first, I'm happy to do that. But I'll be very short anyway on what I want to say, because I'm not very sure, to be honest, hearing all that. What's the best approach? From a business point of view, I see value in the main proposal, in the principles, but the amendment also makes good points. And Deputy Alex's questions on licenses, consistency, and the venue staffing impact are still very relevant. However, the parishes should still continue to be engaged in the process in some form. And all those questions raised about, is it the best place on the gambling committee? So the questions that were raised from the other members do need further clarification to make sure we do implement the best system. I'll appreciate a bit more views on this, and that's why I support the reference back.
Thank you, Deputy. Deputy Scott.
Ma'am, I just wanted, I felt a bit uncomfortable about the reference back because I didn't really feel like I'd heard more people had to speak, and in terms of the fact that the reference back is based on very specific information that has to be asked and reported back from the panel, and actually prevents the panel, in a sense, from just calling it in after we approve the principles, was, a reason why I felt uncomfortable with it. Then I was informed that perhaps the chair himself had suggested he wasn't, which was what motivated the the actual proposition of Deputy Howe. So I think I will leave it to Deputy Tadier to take.
Councillor St John.
Thank you, Ma'am. Ma'am, I don't support a reference back because I do think we need further information. I think scrutiny is probably best place to do that, Ma'am. We've got an industry that have been asking us to modernise the laws for their industry for decades. And here we have got an attempt to modernise those laws. I don't agree with all of it, Ma'am, but I do agree with supporting the principles and then proposing that it goes to scrutiny. So I won't support a reference back. I would strongly support, as the Minister said in his opening, the proposals going to scrutiny for further information. So I would urge members to not support a reference back, but to support this being referred to scrutiny. Thank you, Ma'am.
Deputy Reniff.
I would be happy to defer my speech to him.
Deputy Tadier, you're next on the list.
Thanks, sir. That's kind. The reason I've held back now is because I wanted to hear as much of the debate as possible from members. And there are a few things I think I do need to put on record, speaking on behalf of the panel initially, is that this is a brand new law. So this isn't a small thing that's coming to the Assembly. It's a complete overhaul of a system that has had mixed feedback. So it's true that some in the hospitality industry say that they want a modernised system, but it's also equally true that others say that the system currently works very well for them, they know it, and I haven't heard any criticism of the current system and the way it's operated from a judicial point of view. There might be some things that are antiquated, but others have told me that actually it's very easy under the current system to pick a phone, because you know that the parishes themselves, there's always somebody at the parish hall, well, not all the time, but 5 days a week they tend to work, and that the bailiffs' chambers work 5 days a week. So there is a contention on the one hand about the urgency of this law versus the fact that actually it's working quite well, and if this law isn't passed today or indeed this term, that nightclubs, pubs, off licences are not going to go anywhere, they're still operating. The second point I would make is that we are now into a very busy period of the political term, the very last few weeks, where we have a very shortened meeting period. So instead of the usual 3-week cycles, we're pretty much moving to a 2-week cycles, which also coincides with parliamentary business being much more rapid. As the Minister for External Relations said, acting as the Finance Minister effectively, which is his dual role, he acknowledged that there is going to be much more legislation coming down the pipeline for both his department to lodge, to move, and for our scrutiny panel to scrutinise. And this is not going to be insignificant work for us to do within what remains the next 4 sittings. But as I've said, the next 4 sittings are really taking place within the space of what would normally be 3 sittings. And that last week, I would suggest, is going to be a very busy and potentially very contentious sitting. So we probably haven't seen all of the propositions that are going to be lodged as members, perhaps especially new members, decide that all of those things that they've been meaning to do for the last 3.5 years that they promised their constituents, and perhaps not even just new members, will be finally lodging something in the next 2-3 weeks so that it can either make it onto the penultimate or last sitting of this Assembly, sir. I would question, if this law is so urgent, why has it been left to the last 4 sittings of this Assembly? And why are we being asked by both sides, i.e. the side that has fundamental problems with it, the constables who are currently heavily involved, who have put their own amendment in, why are they urging my scrutiny panel to scrutinise this? And why is the Minister urging and indeed presuming that my scrutiny panel will scrutinise this? Is it because he thinks that we can add some value to it? Or is it because deep down, I think we all know in this Assembly that what's being put before us today isn't necessarily fit for purpose? It may not be fit for purpose on a technical issue, but it may be also that there's a political naivety and that there are political flaws in this, which simply can't be resolved by my scrutiny panel, sir. So one of the issues is, and I've had some correspondence with my panel in a shortened period of time, is that I'll read I won't name anyone, but the point is that there's a strong view that this law is incomplete. And this is the point I would highlight, is that we should not be getting involved, we should not be getting into policy arbitration, a policy arbitration position as a scrutiny panel if this is in effect still policy in development. And what I would say to members is that what is it that you expect our scrutiny panel to do with this? Because we can't do government's work for it. We can certainly, if there was a joined up piece of work that was coming forward saying, look, we've done a proper consultation, and I must admit, I've come into this with an open mind, and I've read through the comments paper. There's a lot of talk in here, in the comments paper to the Constable's amendment saying that, so this is the Deputy Morel speaking, and the Minister, it was for this reason that my department undertook briefings with constables. It goes on to say that it was noted during a council, when the chair of the committee noted during a council of ministers briefing, etc., and then later on, the decision to assign alcohol licensing to the Gambling Commission was made in late 2024 and was communicated to the committee during the initial November 2024 briefings. So there's a lot of talk about briefings, of communication. This is what this is what we are doing. But what I'm not necessarily hearing is that the full consultation has taken place. And on the one hand, I think we've heard from the ministerial team that the consultation has been extensive. And I think it is correct that there seems to have been a lot of consultation with the industry. What there doesn't seem to have been is the consultation with the Comité des Connétables, because otherwise I don't think we'd be in this position where there'd be a counter offer, i.e. this is a different way to do things. And I know we could say, leave that to the second reading, because these are actually amendments, but I think the amendments are so fundamental here that they actually have a fundamental impact on the meaning of the principles. So with all that said, this is in no way me or my panel shying away from doing a job of scrutiny. We will do that if it is the desire of this assembly to refer it to us. But I think that the information that is being requested is not one that we can do as a scrutiny panel. We're not here to provide alternative policy. We're here to scrutinise government policy. And it seems to me that the current government policy is not fundamentally acceptable to this assembly. And therefore, it does need more work from a ministerial point of view before it comes to scrutiny, sir. Whether that's done in this assembly, I think it's increasingly unlikely that we should shoehorn such a fundamentally new and different way of doing things into the last few weeks of an assembly. It might well be that actually by referring this back, by allowing that space for conversation between the committee and the Minister's Department, under perhaps a new open mind policy on both sides, that there could be a new way of doing it. I personally think I was initially completely impressed, and I still believe we need a new law, but I think that there is something to be said for the potential of a devolved but perhaps streamlined system which could involve either a central, one parish could take responsibility for all, but I'm still open-minded, and so I will support the reference back, but actually when it comes to, if we do get to a vote today, I think myself and the panel would be abstaining on the principle, sir.
Deputy Reniff, did you now wish to speak?
Yes, okay.
You're not obliged to.
No, I hope that the Minister will speak. He hasn't indicated a desire to do so yet. I find myself in a slightly difficult position. I suspect many members do. I think on balance at the moment I'm minded to not support a reference back. I think the fundamental principles here are the two principles that I've certainly picked out feel to me to be ones I support. They are that the current law is complex, it's unnecessarily burdensome for business, and it feels to me like the simplifications that are proposed in the broad sense in that area are good. And similarly, I am comfortable with the idea of creating a new body that, I don't know if I'm using the right words, forgive me, but more democratic, if you like, a civil body that would oversee that. And those two broad principles, it seems to me, I'm happy to support. I do think that it will need quite a bit of work in the phase between the first and second reading, however we achieve that gap. But I think we do need that gap, and so my reservation is if we can't find a way of creating that gap, then I would have to support a reference back, because I do think it does need more work. So, as I say, I find myself in a slightly tricky position, and I would like to hear what the Minister's preferred way forward is.
Deputy Balash.
So I do have a feeling, as with some other members, that this law is not really fit for purpose as it is. And at first I was minded to agree with the Constable of St. John that the solution to this was to send the law to approve the principles and to send the law to the scrutiny panel so that it could be thoroughly scrutinised and hopefully come back with a number of substantive amendments from the panel. Having listened to the chairman of the panel, I'm not sure that that is necessarily now the right solution, and I'm more inclined to think that we ought to refer this back to the Minister, because it needs a rethink. I don't really want to vote against the principles, because the principles contain a number of very good things which ought to be amended, ought to be achieved. But I feel quite strongly, I must say, for all the reasons given much more eloquently by the Constable of St. Helier, that the existing way in which we do things through the licensing assembly is fundamentally okay, and that we ought not to tear it up. And I would like the Minister to take this back on a reference back and to rethink whether it is necessary to send the to establish the Gambling Commission as the Gambling and Licensing Commission. I think that would be a false move. Equally and unfortunately, I don't think that the amendment from the Comité des Connetables really works either. I don't think that it is feasible to have a system whereby the parish assembly reaches a conclusion on a licensing application, and the constable then has to exercise the role which the Constable of St. Helier described so well as holding the balance between different forces which might not have worked out well before the parish assembly. So I hope I will, on reflection, vote for the reference back that Deputy Howell has brought.
Deputy Curtis.
Thank you, Ma'am. I thought I would speak because I dare say I recognise the reasons given for requesting a reference back from my speech, though I did not prompt this. I, like Deputy Renniff, would very much like to hear from the Minister on this reference back. The key point Deputy Balash made there about wanting to support the principles at their highest level, I think, stands true. But I try to put my mind in what would we see if we were to predict in all likelihood the outputs of a scrutiny review, however short or thorough. What would it look like? And I'm thinking about the findings and recommendations. And on the information in front of us now, the findings may be insufficient. Information has been provided as to the function and the role of the Commission. The recommendation may be to clarify that. And equally, it may be on providing conditions, and looking back to the report, the ambiguity around licence conditions being bespoke to businesses, changes or decisions made in real time, responsive to neighbours. The response from scrutiny may be clarity as to how conditions are formed, standardised, is not yet set. And I really think that given we are replacing all these categories with very well understood ideas with something completely new, scrutiny will have a hard chance going into this. But if the Minister can convince the Assembly that his role in assisting scrutiny is to provide evidence and a forum in which scrutiny and ministerial information is forthcoming, I could sit on either side of this, but I think we all need the Minister to clarify how information would be forthcoming through the scrutiny process and just of his own volition.
Councillor St Brallard.
Thank you, ma'am. And having listened to other speakers, I think it's becoming clear that further work needs to be done. And I hear the chair of the panel and what he says, and I understand scrutiny and how it works. It is quite clear. Scrutiny is not there to come up with policy. That's not its role. And I think it's being proposed now that it be referred to, the matter be referred to scrutiny is actually unfair on the panel. And that leads me to suggest that I feel a reference back is probably the sensible way forward. I think what the Minister's proposal has done is stimulate conversation on the matter. And if the committee were late coming to the table with its comments, well, I apologise for that, but certainly, ma'am, it has the effect of catalysing discussions, which I think at the end, whether it'll be this term, I doubt, but even if it comes to next term, I think it'll produce a better law, better for the industry and better for administration throughout. Thank you, ma'am.
Deputy Farnham.
Thank you, ma'am. I speak as somebody who's not for 7 years, I've been a director of a company that holds a licence, but have been in the business most of my working life, and I can say without a doubt that this draft law is a forward-looking piece of legislation, of regulatory reform that is long overdue. And I know change is always hard sometimes, but we haven't had too many amendments. We've had the amendment from the constables. But members are coming today with some concerns, but they can't quite put their finger on it. And I'm not sure that's a strong enough reason of feeling that something isn't right. Sometimes it's right, but sometimes it isn't, and they should look more closely at the detail. I also think what scrutiny are being asked to do is to scrutinise this. That is the role of scrutiny. It's an important function in this assembly, in ministerial government. It's how this assembly works and counterbalances and holds ministers and government to account as it scrutinises and reviews its work. We're not asking scrutiny to change policy. Scrutiny we would be asked, and I hope scrutiny do take a look at this. I understand what the chair said in relation to timescale and that, but there is time to do some work and bring it back for this assembly to consider. If it's minded to scrutiny, might say, look, this needs a lot more work, in which case we would have to consider how we move forward then. So I would urge members not to support the reference back. I would respectfully ask the chair of the scrutiny panel to consider calling this in so they can have a good look at it. We're not asking them to actually come up with anything, but have a good look and make a judgment on what they feel they would like to do, ma'am. So I'd urge members not to support it. I align myself with the views of the Constable of St John. I also am very mindful that some members feel uneasy about it, but I have looked closely at this. It is an important piece of regulatory reform, and I think we're heading in the right direction with it. Thank you.
Does any other member wish to speak on the reference back? Councillor St Mary.
Thank you, ma'am. I had put my light on earlier to speak on the main debate, and we've moved on from there, but the point of my intervention then was to suggest I should say something as the sole surviving member of the Economics Scrutiny Panel back in 2014, 2018, when the panel considered what was then, I think, a 17th revision of the draft law. And the thrust of that law or proposition was to replace the present licensing authority with a new panel made up of states members. I'm not allowed to say God forbid, ma'am, so I will say that horror of horrors. And that would be equivalent to what the planning panel does now, and that's no reflection on what they do, but I think for members to have taken on that role would have been very much a backward step. apart from which there's a time factor taken up by 6 members. But that was the thrust of the proposition, coupled with one aspect. And during that review, we, as a panel, had the benefit of a presentation involving members of the Licensing Assembly, and it's quite clear from them that they're quite happy to continue. If there were problems as to inflexibility, which they didn't recognise, they would be more flexible. And in the fullness of time, the panel of the day prepared an amendment which encompassed that. It also addressed the other main question, which I think was and Deputy Barrish has raised this, the health aspect. Whilst it was then as now, the province of the Minister for Economic Development, he really was, I think, guided through COM, no doubt, by the Health Minister of the day. There was a very strong health aspect to the whole thing, and again, a further thrust of the proposition was to, before you could apply for license, you had to fulfil 5 conditions, and it's taken from the UK situation. But we have moved on from there, and the reason I mentioned that is that Deputy Parish did refer to the health aspect being not in conflict, but there be a tension between the health aspects and the licensing aspects. My own view is that I don't think it makes much difference as to how many licensing outlets there are. If an extra one, that presumably will diminish the trade from another one. I don't think increasing the number of licenses has a detrimental effect on health. And as has been pointed out, many of these licensing outlets sell alcohol as a byproduct almost. So what I'm really saying, ma'am, is that I think my main concern on the legislation as now drafted is the removal from the present licensing authority of it being the final arbiter. If that were restored, I believe that I would be quite happy to go along with much of what else is in the law which is beneficial. So on balance, I think I would vote against the reference back on the basis that we continue with the principles, and also on the basis that somewhere along the line a suitable amendment could be made which would cover what I think is the main difference of opinion. So on that basis, I'm not totally convinced, but I will be against the reference back. Thank you, ma'am.
Councillor Trinity.
Thank you, ma'am. When I came here this morning, I was fairly convinced that I would be happy with this proposition just to be called back in, or the principles to be called back in for scrutiny. But the longer the debate has gone on, and the more difficulties that I see arising, that I really feel that we're going to throw the baby out with the bathwater if we're not very careful, when there's not a lot wrong with the baby that can't actually be regularised with a proper review of the whole thing. And I think that what we're asking the scrutiny to do is going to be too difficult. I think that basically the first principle is not correct, in that there's nothing wrong with the system that works at the moment, other than it needs a bit of modernisation. And I really would say that I'm actually more in favour of supporting the reference back. Thank you, Madam.
Deputy Gorst.
Ma'am, it was point of order. Can you rule that it is appropriate and possible, under standing orders, to reference back to scrutiny during the second reading of a piece of legislation? Therefore, members could agree the principles and then reference it back to scrutiny in the second reading, once the Minister had opened the second reading.
You're not referencing back the matter to scrutiny, you're referencing back the matter to the Minister, Deputy.
No, ma'am, I'm asking a totally separate point of order, not in relation to this current reference back.
Are you asking whether under Standing Order 72.2 you can ask that scrutiny look into the matter?
Indeed, during the second reading.
May I turn to this? I understand that if the Chair of Scrutiny declines to call the matter in, any member can bring a proposition under 72.2 requesting the Assembly to refer it to scrutiny. But your clarity would be appreciated.
I mean, it strikes me a question, particularly of timing. Yes, understanding Order 72.2, a member can ask that the Chair of Scrutiny or Scrutiny Panel considers whether or not to take the matter forward, and they're required to think about that and come back. There's also Standing Order 79, in which we can ask to suspend the debate for the purposes of scrutiny, but again, it rests with the chair of the panel and the panel as to whether they accept that reference. There's no requirement for a scrutiny to be undertaken, as far as I can see, in standing orders. If the panel themselves do not feel that it is something that they are able to assist with, all it will do would be to delay that being said by the chair, because he would be asked to come back at the next meeting, at which point he would then say whether or not they would consider taking the matter on, I suppose. But behind the scenes there could be some discussions that would take it away from this chamber, but ultimately it would still rest as a matter for the scrutiny panel as to whether they take the matter forward.
Thank you for your clarity, ma'am. So I think you are saying, just to make it clear, that a reference to scrutiny can be undertaken in the second reading, but that reference to scrutiny then falls into scrutiny's hands, and they could return at the next sitting and say they've done a review, they're not going to do anything further. Or they could undertake a review. It rests with them.
Yes.
Yeah, thank you.
Scott, sorry.
Yes, sorry, just if I could understand if there's a distinction here. So if Deputy Howe, say, for example, were to withdraw this proposition and it went to, we approved the principles, and scrutiny said they didn't want to call it in, but a member proposed that it be referenced back to scrutiny, scrutiny could refuse the reference back. Would that be true or not? They could refuse the reference back? Because I'm trying to understand if they could do that now anyway. No, but you can force the reference back on him. That's one of... Oh, I see. Right.
Yes, it is my understanding, and that of standing orders, that ultimately all you would be doing is delaying the inevitable. If the chair is adamant that it's not a matter that he feels his panel can assist, then all you'll be doing is pushing that to the next meeting for him to say so. There is no onus on him to undertake the scrutiny of a matter that has been referred. That's my reading of standing orders.
Well, may I ask something? I've got to ask a point. I don't know if it's a point of order, but about this reference back. Am I right in thinking, from my reading of a reference back, a set of, if you like, questions are raised, agreed those are the specific areas of a reference back that goes back to the minister. If the minister comes back and has answered those questions, that's what the minister is asked to do. It's not a general thing about whether it's the right thing or we agree with it. There's specific questions that are being asked by the person who's proposing the reference back is what we should be talking about, debating and deciding on. I would suggest, ma'am, that if we were to put a quiz out, say what are the 5 things to everyone in this assembly, we might not all know. And I just wonder whether we need to revisit those before we continue this debate. Thank you, ma'am.
Deputy, I think it's a good suggestion, and I was planning on asking Deputy Howell to revisit the 5 points because I'm sure not everyone took note of them, and they were quite descriptive, and I think would be incredibly helpful for the Assembly and for the Minister to know exactly what was being asked of him as part of that reference back. You're absolutely right. A reference back should be contained to a specific set of questions. Deputy Ferry, you're next on the list.
Yeah, so mine was a question of point of order as well. So under Standing Order 83, if presupposing this reference back is unsuccessful and then we proceed to vote on the principles, can there be a further request for a reference back in second reading? So is there 1 bite of the cherry or 2?
I think it would be, we would have to move into second reading, and then there's a potential within the debate on the articles for a second reference back, potentially. But one wonders whether you would wish to take that. I think if the Assembly is chosen to move forward, then it strikes me it makes more sense to either vote for or against what is being presented. Any other member wish to speak on the reference back?
Ma'am, before I speak, I would be grateful if Deputy Howell could just reiterate those 5.
So, ma'am, I don't think that's correct point of order. That's not the correct procedure. Deputy Howell's made her points in the opening. It's up to us to recall that, and she'll make them again in the summing up if she wants to. Otherwise, it's a third speech.
I have to agree with Deputy Tadier. I've already said that we will ask Deputy Howell to reiterate the list. They were quite detailed.
But that would then be a third speech.
Well, no, she'll be making that at the end when she sums up from the reference back. So do you wish to make your speech now, Deputy Morel?
If I may, ma'am. Ma'am, sometimes it is best just to let people speak and hear what they have to say. It's been fascinating undertaking this alcohol licensing, draft alcohol licensing Jersey law review over the past 3 years. Well, I started 3 years ago. We went into the more consultative phase in September 2024. If members would be kind enough to check their inboxes, they will see that there is a message from me which clearly highlights and states when the parishes were engaged with by members and by myself, and how they have been engaged. Because one of the incorrect assertions that has been made during this morning's debate, ma'am, is that the parishes haven't been involved. The parishes, and there's even been a suggestion that I believe it was the Constable of St Helier who said that why, the parish shouldn't be diminished further. There is zero diminishment of the parish role in this proposal before everyone today. Zero diminishment. It was a clear order from me to my officers that the parish roles should not be impacted in a negative way, precisely because I could see the Connétables, well known to be a conservative section of the Assembly, would likely be upset if their role was diminished in any way. So the first piece of engagement with the parishes was on 20th of November 2024. Various Connétables attended that briefing. And it must be said that one Connétable in this Assembly said in the Council of Ministers meeting just a couple of weeks ago that there had been no consultation with the parishes. I pointed out that that was an incorrect assertion. On the 21st of November, various other Connétables were briefed. On the 5th of November 2024, the parish of St Helier, including the Connétable, were briefed. On the 23rd of December 2024, we went through a 12-week public consultation. This was open to the public, including the Connétables, to engage with that consultation, which went on for 3 months. In 2025, 26th of January, the public consultation closed. Sorry, that was a 4-week, not a 12-week public consultation, my mistake. 10th of March, the Comité des Commentables, St. Villars Parish Hall. I sat there with my officers. I listened to the Connotables who were in attendance. The Connotable of St. Helier was not in attendance that day. At the end of that meeting, and I believe that the minutes of that meeting show this, at the end of that meeting, the Connotable said that they had no objections to the law, but they did know that the Connotable of St. Helier was considering bringing his own amendment to that law. I understood that. At that same meeting, the Connotables of St. Peter asked for an enforcement power to be provided to the chef de police, enabling the chef de police to be able to urgently close down a premise should there be a need to. He stated at that time that he was particularly aware that in his parish he had premises out on a 5-mile road where it could take the police some time to get there, and in an extreme situation they may wish, the chef de police may need to be able to close them down urgently. Very unlikely, but possible. And so I took from that two things. One, the Connotables had no objections because that's what they stated at that meeting. And two, that there was this desire for an enforcement power. I very clearly, very amenable to the Connotables, walked away and asked my officers to include such a power in the draft law. We have done so at the request of the Connotables. The 25th of March, Council of Ministers, Deputy Howell, to my left, said she has had no chance to engage with this law. This has been to the Council of Ministers on a number of occasions. Deputy Howell sits at the Council of Ministers, though not a formal member. It is well known, and the Chief Minister has said in this Assembly on a number of times that Assistant Ministers are invited to all Council of Ministers meetings. Deputy Howell was invited to those meetings and took part in those meetings. She has had more than one occasion on which to engage with this law. We did a closure order workshop on the 17th of June. That involved parishes because that was also about their ability to close down premises, because though it sounds easy when there's some drunken people rioting, closing down a premises is not always the right thing to do, because you've got rioting people spilling out into the streets. Equally, a chef de police on their own, faced with several drunken, brawling people, may be at danger. So there is an important need for them to understand that, the role of such a closure order. 13th of October at St John's Parish Hall met the Comité des Commentables. 29th of October at St Helier Parish Hall, I again personally met with officers of the Comité des Commentables. And on the 3rd of December, we went to the Council of Ministers yet again. We were also in the Council of Ministers last week talking about this, and the Council of Ministers sitting before last week, we talked about this as well. So Deputy Howell, when she alleges that she has not had a chance to engage with this, I would prefer to differ on that point. It has been very clear to me throughout that since the Connotables came forward with their amendment, there has been a serious desire to effectively try to derail this legislation. I have had ministers in my own shared council of ministers that I sat in working against the legislation itself. I noted earlier that the Constable of St. Peter was vociferously banging his feet on the floor in the manner of a gleeful young person. And it was brought to my attention that the Constable of St. Peter had been lobbying people with regard to this legislation. I'm not sure that sits within the ministerial code very squarely. I, ma'am, have been very open from the very beginning of my term of office that this was a piece of legislation that we would love to see brought forward. Industry has made it very clear that it wishes to see this brought forward. There has been ample opportunity for every single member of this Assembly to engage with this piece of work. Deputy Curtis has had the opportunity to engage with this piece of work in many different ways, whether through the public consultation, whether through engaging with the office. He's known this work is being undertaken. The law was lodged. He was able to ask any questions about the lodging of that law since then as well. I think, as I started this speech saying, sometimes it's good to let people speak, because what I see is a law before us which, in the principles, does no harm to anybody except sets the direction for a modernised system that the economy of the island can get behind and helps the economy of the island. What I see as people in this assembly try to derail it, I see people who yet again seek to stifle the economy of our island on the altar of their own preference for a status quo. Potentially, there are benefits that they wish. One Conatable, myself and the chair of the JHA were in the street in December. One Conatable sat in this assembly, came up to us, and I asked, what is this amendment about? And that Conatable said words to this effect: it's about getting the power. That was what that Conatable said to us, and I have the chair of the Hospitality Association as a witness to that event. Words to that effect. I have not named any Conatable. I have just said about a Conatable who approached me and the chair of the Hospitality Association and said it's about gaining the power, or words to that effect.
Deputy, I feel you're coming close to impugning the motives of a member, and I just would like to urge you to guard against doing
I appreciate that. I haven't named any members. It strikes me that we can here have the opportunity to really show the island that we're an assembly that wants to take things forward, that we have a parliamentary process which is designed to help work through such disputes and debates. I cannot think of a better reason for scrutiny than where there is a difference of opinion on a matter, and for scrutiny to come in from their evidence-led approach and sit down and look at the differences of opinion and try to plot that way forward. The chair of the scrutiny panel called it policy and development. It is not policy and development. The policy is before us today. There is an amendment which suggests a wish for a different path, and that's entirely valid. But that is not policy and development. The policy is fixed here and is here in the proposition before us. Actual alcohol licensing policy will be developed over time through the mechanisms that this law provides. But to hear the idea that scrutiny does not think this is an appropriate place for scrutiny makes me question what on earth is the point of scrutiny at all. The chair of the scrutiny panel told us about some legislation that the Financial Services Minister wishes to bring forward. That's wonderful. The Financial Services Minister hasn't lodged that. That may or may not come forward. I don't doubt the intentions of the Financial Services Minister, but those propositions are not before us. They have not been laid before the Assembly. This one has. I've heard that I've heard the scrutiny chair ask, why has this been lodged so late? This has been worked on for years. The intention was to lodge it in September, but as other ministers, and anyone who has acted as a minister or an assistant minister will know, law drafting is its own particular entity. The only reason this has been lodged when it was lodged is because that's how long it has taken to get it through the full law drafting process. Again, that is not a criticism of law drafting. That is what has happened. I have been chasing officers every week since September. Please, we need to get this laid before the Assembly. Please encourage the drafting process to be faster. Please hurry this up, because I wanted to ensure that scrutiny would have the full 4 sittings in which to do their review. I did not wish for scrutiny to in any way be impaired in the amount of time that they have to review this legislation, this proposed legislation. And that remains today the position. We are debating this today because it has taken this long to get the law drafted. No other reason. Nothing on my part. I would have wished this to have been in the Assembly back in September. But we are here. And we have those who do not wish to see progress in this island trying all sorts of mechanisms, from reference backs to trying to avoid scrutiny of the process as a way to force a reference back. It was an incredibly complex set of questions that were asked as part of this reference back, that were read, and you know, I accept that I'm sure people thought of those questions in advance of this sitting today. But again, there has been plenty of time for both Deputy Howell to approach me As a member of the government, Deputy Howell is in a particularly unique and privileged position to approach me, in which she can have asked these questions. As well as the list of timeline that I have provided all members today of engagement with the parishes, I have a further list, which I am happy to send on, which shows over 50 engagements with the parishes, with the police, with the fire service, with public health, with other departments, all going back to 2024. There has been no lack of engagement on this piece of draft legislation. And if members wish to stick to that myth, then that is their right. But it will make it clear who in this assembly wishes to have economic progress and provide a business-friendly environment for businesses in Jersey, as opposed to those members who prefer to maintain a system which does not work for business. Deputy Balash talked about if it ain't broke, he was not the only one, don't fix it. That's fine. And I'm sure from the people inside the system, it doesn't look very broken. To the people outside the system looking in and working with that system, it is very broken. There is a letter that has been sent to all states members from the President of the Chamber of Commerce and the Chair, the CEO of the Jersey Hospitality Association. It clearly states their strongest desire for change and reform of the system. It also clearly states how that when they took part in the Connotab's first ever piece of consultation on this draft law and their draft amendment on Monday afternoon of this week, that the Connotabs did accept that in principles, the licensing part, the policy part around this was something that they supported, that the only issue was around the administration. And that is where I say scrutiny is ideally placed to weigh those two pieces up and think maybe the Connotabs have something, maybe the minister has something, or maybe there is something that the scrutiny panel wishes to do. I cannot think of a better role for scrutiny than that. And if scrutiny doesn't wish that role, then I think we do have to question what is the value of scrutiny. So, ma'am, I strongly urge members not to support this reference back, because I have laid the evidence before them of the extensive consultation with parishes, with Deputy Howell, with members of the Council of Ministers and others over the last 2 years and more.
So can I
Thank you,
ask, Ma'am, can I ask a point of information or clarification rather of
You're prepared to give way, Deputy.
I don't know if this is helpful or not, but it's a genuine question. Given the scrutiny panel doesn't appear keen to do this, is there the possibility that if this is passed in the principles, that the Minister might consider not proceeding with the second reading in order to create a gap, in order to allow some of these debates to happen, not necessarily through scrutiny?
Sorry, ma'am, if I may, this is meant to be a point of clarification of something in my speech.
So I'm asking whether the Minister would be prepared to consider that as an extra point.
It's not really a point of clarification, Deputy Renouf.
Mum, could I
will consider anything to help smooth this through.
Thank you. Sorry.
Could I propose the lunch adjournment? I think it may be beneficial that people could get around a table with a sandwich and see if they can resolve matters.
That's very wise. The adjournment has been called
Mum,
for.
can we have? I don't think it is wise to adjourn. I think we've come to the end of.
There are, Deputy, if you don't, there are two members who still have indicated that they wish to speak. So I think that we're not really at the point of going to a vote as yet. I don't know if any other member wishes to speak on the reference back. They'd like to indicate just to give us an idea.
I may wish to speak depending on what gets said next.
When the adjournment has been called for, is that proposition seconded? Do members want to show if they're favour? Those in favour of the adjournment? Those against? Then the state's adjourned until 2:15.